Do not have the prosecutor. That's no, we're good. Court does call the case of People versus Jenny Lou.
Good morning, this is Defender Lauren Kearney on behalf of Ms. Lou. Ms. Lou, please state your name for the record.
I am.
Jenny Lou.
Okay, here you are. Okay, go ahead, Mr. Perry.
Your Honor, today's the date and time set for sentencing. I did review the recommendation with Ms. Lou and we ask that you adopt it. This is the last case that Ms. Lou has pending before this court. She is expected to be released in April after serving, I believe, 5 years in prison. While in prison, she's done a lot to improve herself and make her time there productive, engaging in things like mental health therapy and things like that. I do, again, ask that you adopt it, and I do wish Ms. Lou luck on whatever comes next for her.
Ms. Lou, is there anything you'd like to say before I impose sentence?
No, Your Honor.
All right. Sentence of the court. Statutory fees of $125, 365 days in jail, credit for 365 served. And I would join counsel. Ms. Lou, we're going to miss you. I don't know how many times I've seen you before. All right.
I know, right? It's been a journey.
Once you're released, I wish you all of the best.
Right. Thank you. I appreciate you.
All right. Take care.
You too, Your Honor.
Court does call the case of the People versus Cameron Reeves.
Assistant Public Defender Natalie Kay on behalf of Mr. Reeves, Your Honor, who I do not believe is present unless he is on Zoom.
I don't see.
Your Honor, I'm not sure where he is. I unfortunately don't have his failure to appear. I did make numerous attempts to try to reach him prior to the day's sentencing. It is my understanding he did complete the interview. There was a PSI completed. I also did as well with his mother. Unfortunately, I do not have an explanation for his failure to appear. Requesting the record.
And Teresa Claire on behalf of Probation. Your Honor, Mr. Reeves did complete the PSI. However, Mr. Reeves does have a history of not appearing before this court. Probation would request a report.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. There having been previous warrants, this warrant will issue immediately. Court does call the case of the People versus Julian Teran.
Is that Teran, Your Honor?
Yes, Teran. Teran, I'm sorry.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Teran. Mr. Teran, please state your name for the record. Say it again, Mr. Teran. You sound really faint to us.
Julian Teran.
Yes, very faint.
Here, let me try again. Can you hear me now?
Yes, that's much better, sir.
Okay, Julian Teran.
Thank you.
Your Honor, today is the date and time set for sentencing. We did the pre-sentence report and do not have any material changes or deletions. We do ask that you adopt the sentence recommendation. Regarding the restitution, my client did inform me he's planning on coming up. I did inform him the restitution needs to be paid in person in cash. He is planning on coming up to the court to pay $330 today in person. As for the rest, he is planning on paying in installments if the court allows.
Teran, anything you want to say before I impose sentence?
I'd just like to echo Warren said. I'm be coming to the court to make a payment. I'd hope I'd receive probation I'm happy to comply with making payments for the restitution. That's it.
On count 4, it's the larceny 200 to 1,000. It's the sentence of the court, 24 months probation, $555 fines and court costs, $720 probation oversight fees, and $6,030 restitution to Tetra Tech payable through the court. How were you intending on paying that, sir?
I spoke with the probation officer, and I was going to make monthly payments of about $330. I forgot the exact number, but it's around that ballpark per month. And I have a job.
So you're going to pay you're going to come up today and pay how much?
I believe about $330 of this.
All right.
Redone.
I'll put you're going to pay $330 today. That is going to be paid in cash. That goes to the restitution. And then I will indicate a payment plan as arranged by probation. All right, for that amount. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 90 days. You are to complete 25 hours of community service as directed by probation. There is no going to Tetra Tech on Oak Valley Drive in Ann Arbor, Michigan. You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2, the balance is suspended. On count 5, 24 months probation. You're to pay $455 fines and court costs. That will be wrapped into your payment plan through probation. You're to comply with all terms that I set forth in count 4. I'll order 90 days in jail. Credit 2, the balance is suspended. Thank you, sir.
Thank you, Your Honor.
Court does call the case, People versus Justin Tiddle.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Tiddle, who appears via Zoom. Sir, can you please unmute and state your name for the court?
Justin Tiddle.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the PSI with Mr. Tiddle, and we have no material changes or corrections. And as to the sentencing recommendation, would be respectfully requesting this court to adopt it.
All right, Mr. Tiddle, anything you want to say before I impose sentence?
Sorry for the inconvenience and God bless.
All right. Sentence of the court, $125 statutory fee, 90 days in jail, credit 90 served. All right. You're all set. Good luck to you, sir.
Thank you. You have a good day.
Thank you, sir. Thank you, Your Honor.
Court calls the case, People versus Frederick, Warden.
Public Defender Attorney on behalf of Mr. Warden. You're coming in person. Please state your name for the record.
Frederick James Ward, second.
Your Honor, today is the date and time set for sentencing. We did review the sentence recommendation. Believe it to be fair. We do ask that you adopt that recommendation.
Sir, is there anything you'd like to tell the court before I impose sentence?
No, sir.
All right. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of intensive outpatient treatment and attendance at 12-step meetings. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to prevent recidivism, promote change, and to monitor compliance with recommended treatment. Therefore, the sentence of the court, I'll place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. When can you get that paid, sir?
I'd like to make payments if possible. I have 200 on me today.
You have 200 today?
Yes, sir.
Thank you for that. So pay 200 today, and then the balance is arranged by probation through a payment plan.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an IOP program, including all recommended aftercare, the status reports to probation. You are to attend 2 AANA meetings per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. All to 93 days in jail, credit 3, the balance is suspended.
Yes, sir.
All right, thank you. Court does call the case of the People versus Christopher Fair.
Assistant Public Defender Natalie King, on behalf of Mr. Fair, Your Honor, who I unfortunately do not believe is present today. I did leave voicemails at both times. Mr. Fair, unfortunately, I did not hear back. And it is my understanding there is unfortunately also an outstanding bench warrant out of 14A2. Outside of that, Your Honor, I do not have a further explanation for his failure to appear and respectfully request an adjournment for the record.
And Teresa Blair on behalf of probation, Your Honor, this is a review hearing before the court. However, Mr. Fair is non-compliant with the terms ordered by this court. And given that he is also not here and has other bench warrants out there, probation would request a bench warrant in this case.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I will give a 10% privilege on that. That warrant, however, will issue immediately given previous warrants. Court does call the case, People versus Bilal Howard.
Assistant Public Defender Natalie King, on behalf of Mr. Howard, who is present via Zoom. Sir, can you please unmute and state your name for the court? Mr. Howard.
Wow,
Hello, Howard.
you got him?
Yep.
He was under a different name. All right.
Teresa Blair on behalf of probation, Your Honor, Mr. Howard is scheduled before the court for a review hearing on a prosecutor deferred sentence. Mr. Howard is non-compliant with the terms ordered by the court in that he owes $1,305. He's made no payments towards any of his fees. He's failed to complete the MRT program, failed to complete 25 hours of community service, and has not reported to probation as directed. Given that this is a prosecutor deferred, probation is asking at this time that the court set a violation of probation hearing for July 9th at 9 a.m., that Mr. Howard make a $400 payment today towards his outstanding fees, that he report to probation on June 13th, this Friday at 11:30 a.m. in person, and that he become compliant with all previously ordered terms that this court set prior to the violation hearing or face possible sanctions, which could include the loss of the prosecutor deferred and or jail time.
Thank you, Your Honor. I did have the opportunity to discuss this with Mr. Howard as well as the recommendation for probation. He did state to me that he would be making a $50 payment today, which I did check to see that he did make that $50 payment. We are asking that the court adopt probation's recommendation. Mr. Howard can report in person this coming Friday on the 13th, and he does understand the importance of getting into compliance, getting into this programming, and reporting as directed to Ms. Calera and probation. We're asking the court to adopt probation's recommendation, except for as to the money, Mr. Howard does not have $400 today. He did make a $50 payment and does state to me that he will pay $100 next week. As to the rest, Your Honor, we are asking the court to adopt the recommendation.
All right, what I will do is I will schedule a violation of probation hearing that will be set for July 9th, 2025 at 9.
This one.
Yeah, no, it's Braumfield. We call cause number 21-37943, the state of Texas versus Trayvon, Braumfield, that's you? With Mr. Dusler, your attorney and the state's attorney. Do you understand there is a first amended motion to revoke a probation that's been filed that we are going to be working on? Are you familiar with this? Did you have a chance to discuss this with your attorney? Is everybody ready to move forward? Yes. Well, raise your right hand. Do you solemnly swear or affirm that any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand. This states that on April 4th, 2022, in this court, you were sentenced to 7 years in prison, and that was suspended and probated for 10 years for the third-degree felony of theft. Do you understand what this is charging you with? And this indictment was handed up back in 2021, and it states that you were placed on probation on or about June 3rd, 2021 in Jefferson County, Texas. You committed thefts of a value of over $30,000, but less than $150,000. And it's like dirt bikes. You understand? All right.
We can proceed. Judge counts 1, 3, 9, 10.
Let's just, okay, 9. Okay. Was he an absconder?
Yes.
Okay. Well, let's do 1 then. 1. Number 1 states you failed to report to the Jefferson County Probation Office on or about January 31st and May 9th of 2024, which was in violation of your probation order, which required you to regularly report. Is that true?
Yes.
And are you pleading true to that voluntarily, knowingly, intelligently, and because it is true as it is alleged? You understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation could be revoked and you could be sentenced from no less than 2 nor more than 7 years in prison. Do you understand? That's the gap we're looking at if you were revoked. So that's what you're facing, that range of punishment that I would be determining. If I follow, so do you understand by pleading true, that's what you're subject to? Knowing that, do you insist on pleading true to this allegation?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Was he an absconder from May
Yes,
of
May.
2024? Okay. How often was Mr. Brumfield to report?
Any alphabet.
No, but how often were you supposed to? Monthly or bi-monthly? Monthly. Okay. And when was he placed into arrest? When did he get arrested?
He got arrested this year in May of this year.
Okay, so he was gone for a year.
Yes.
Oh,
He was in Carrollton and he had another charge and got arrested
where?
in Carrollton.
Texas, near Dallas?
Denton County, and that was in January of this year, Judge.
Okay. So you've been in custody since January somewhere, but from May of last year to January of this year, you should have been reporting and you didn't. Would that be correct? Okay. 9 states, you committed the offense of theft from person on or about January 11th, 2025 in Denton County, Texas, in violation of condition 1 of your probation order, which states you shall not commit a crime while on probation. Is that true?
Yes.
Are you pleading true to number 9 voluntarily, knowingly, intelligently, and because it is true as it is alleged? And again, the same thing. A voluntary and knowingly made plea of true to 1 or more violations of probation, that's enough to grant the motion to revoke probation, your probation could be revoked and you could be sentenced to no less than 2 nor more than 7 years in prison. Knowing that, do you insist on pleading true?
Yes.
I find you are pleading true voluntarily and intelligently, and you understand and appreciate the consequences of pleading true. All right, I think that's going to be enough here. Let me just look at one thing. Was there any restitution here?
Yes, sir.
Because it's not in the judgment. It says restitution. There's nothing, restitution payable to, and it says not applicable. What the heck?
The motion reflects an amount of $4,752.50, Judge. That's supposed to be from condition 33.
We paid $1,400 was the judge.
Well, restitution was ordered by the signed, by this court in the community supervision order, but it's not reflected in the judgment. Probably what happened is it was to be determined later, probably, and we did the judgment immediately, and then this came after the judgment. I'll bet.
Sure.
But so what's the balance?
The balance right now is $3,312 restitution.
3,312
Yes.
and
50 cents.
and 50, and that's to the complainant in this case.
Oh, yeah.
Yes, sir.
Okay.
Cowboy Sports. It's a name I remember.
All no agreement. So go ahead, Mr. Dusler.
Well, it's obvious that he had problems in reporting, and he explained to me that he just had trouble getting transportation to do that, but he'll also address the court about it. We've got the new charge up in Denton County that has not been disposed of yet. So whatever happens here, he's still got to take care of his business there.
What are we? What were we talking about? A theft of what? What's this?
I don't know the details of it. The ones there, I know it's pending, but he's admitted responsibility for it, and he intends to plead guilty to that. We've still got this restitution owed. He's a young man. He did not have a bad criminal history when we placed him on probation. The good news, I guess, is for a while he did report and he did make payments, and he has paid a significant portion of the restitution. And he's just asking the court to give him an opportunity to hold it in abeyance, let him continue to continue on probation, and maybe he can finish this stuff up correctly. And you'll be able to tell the judge in just a minute. He'll let you talk.
And where's the other crime pending?
Denton County, Judge.
Did anybody tell me anything about that?
I'm looking at a report that reflects that on January 11th of 2025. There's a report that he was involved in stealing from a Domino's delivery driver some pizzas and wings. Whenever they went to arrest him on January 24th, when that subsequent offense arose about him evading. So the theft from a person is from a delivery driver, Judge.
What does the state feel is in the best interest of justice?
Back when he pled originally, I'd offered a cap of 7 years. I felt at that time the 7 years was warranted just because of the nature of his background and all. Your Honor, determined that restitution was a good idea, and I feel like I always understand why you move in that direction, Judge. Cowboy Sports was out. The money that we talked about behind his conduct and another individual's conduct coming over from, I can't remember that. I believe they came from a separate location because I don't remember these two defendants being locals. But they came here, they stole these dirt bikes, and they were caught in the process. They damaged that. That's where the restitution comes from. They were actually able to recover the items, but it's the damage that was resulted there. We had a probation offer on the other defendant, and I know that was a factor as well, that the court determined to do that with Mr. Braumfield. So he was given really a third opportunity whenever he got this probation, because he'd been in trouble before. And even though he was successful for a period of time, he's right back to committing the same kind of criminal conduct. He was an absconder, just failed to report to us for a period of 7 months before he starts committing criminal offenses in another jurisdiction. Now, I know that hasn't been resolved yet, but it sure doesn't look good. And I would recommend that the court not continue this man on probation. That I originally argued for 7 years. I have yet to see anything that warrants any consideration for some time less than that. So I'm going to stand by that.
From probation, anything you would like to?
Originally, when he went on probation, he was sent out to Louisiana. He was a resident of Louisiana, and he stayed out there for a little while, but then he wanted to return back to Dallas, where he said he wanted to live at. But when he got out there, that's when he stopped working. And then they didn't actually accept him in Dallas just because he had some other ones in Louisiana that he had to.
Oh, thank you, what do you have to say?
Oh,
If you want to say anything, Mr. Braumfield, this is your time. This is important, a very important point in your life.
Okay. I have the money to finish my application also right now. And anything I will.
What do you mean?
Well, right now, yesterday, when I sent my probation officer, Mr. Robert, yesterday, I made my parents a call to social office, and that's
I don't hear you clearly.
Yesterday, whenever I see Mr. Robert, Mr. Moore, yesterday,
Yeah.
I had made my normal call to the social security office and tell the social security office how much my balance right now. And they told me that my balance is for $4,650. And I said, okay. And the only thing I'm waiting for is to be released so I can get my money and get very hard and get my probation also. And whenever I was reporting and everything,
Well, where's the money?
the social security office have it.
Okay, here's, well, you're not going to get released to go get it. That's not the way it happens, because we had experience like that before, trusting people. They leave, they never come back. We have to go find them again. And then when they're caught, it could be a while, but you're not going to get released until this was resolved. But I want the money's paid. That would help you. But you're not going to get out to do that. You're going to have somebody on your behalf do it, if that's what you really want to do, which I'll give you the opportunity to do that. But you're not going to get released. You're going to have to work through somebody else, family, or somebody you can trust to get that. And you get it, and you get that resolved. I'm not going to just let you lollygag around on it. I mean, you just have days, not weeks, days to figure that out. But I want to certainly the restitution to victims. That makes a difference to me. That's one way to fix it. Plus, it benefits you in sentencing. I reward people who can do that, even at this stage. But you're not going to get released to do it, because we have a bad experience with that. And we're not going to go try to chase somebody again that Not that you do it, but it's happened before, so somebody's ruined it for everybody else. So that's not what we learned a lesson. If you can get this restitution, I can give you 1 week. 1 week. If you can do it, get it done, get it over to probation. We'll come back, pick this hearing up over here, pick the hearing up where we've left off. And you and anyone else like this who pay the restitution back, the court rewards them. But it's still, you're going to pay it. You're going to pay the consequences here, but you can minimize it to some degree by paying the people back. Are you going to be able to do that?
Yes, sir. The only way I can pay my probation with you, unless I have to go to in front of the Social Security office.
I'm talking about the restitution.
Yes, sir. I have to go in front of Social Security because they don't want nobody else but me because my mama, they're gonna try to go up there and instead so that they want me to go in front of them so I can.
Well, why am I going to let you? I'm not going. I can't release you for that. If you took off, it happened again. Y'all got to figure it out somehow.
I don't think he's gonna be able to access those funds. They're gonna make him do it in person. And I'm not even aware if funds exist, to be honest with you, just based on what he's saying.
Yeah. Well, you're not going to get released for it. You got to figure it out. If you can do it, I'll give you a week to try to get it done. Maybe your family can get the money together. And then when you're able to, you can go give them back that money when you are released sometime in the future. But no, you're not going to be able to amble about to make business arrangements and take care of business needs like this. Not when you've got an evading arrest. You've worn that freedom out while you're on my probation. But you think they might be able to help you in a week, your family?
No, sir, because they won't, because the Social Security, because whenever I went home in 2022, I had to go in front of the Social Security so I get my full $28,000. I had to go in front of them.
Judge is asking you if your family, your mother and grandmother have the money otherwise. Could they get the money to pay your restitution and then you get out and get it from Social Security? Would they have the ability to come up with that kind of money?
The only thing they can try to come up with is my plan so I can go home and try to get my money back. That's the only thing they can try to do so I get my money back.
No, I don't think it's gonna happen, realistically.
Okay. Yeah, let's,
You can reset it, so I think we're kicking the can down the road, to be honest.
Yeah, what we're not calculating into this conversation is the fact that Denton County has a hold on him too, Judge.
yeah, you wouldn't be able to get out anyway. He says they've got a hold. You wouldn't know. You wouldn't know that. He would.
He's got to resolve those, otherwise they're not going to just let him, like you say, amble around you.
Yeah, go ahead.
Oh, I don't have it hold because.
All right. No, it's not a debate.
No,
They know.
I know.
They know if they have information that says there's a hold from Denton County. And as long as that is, and he's good for his word, they know that, then they alert the authorities. Now, they may release that hold, but right now, he says, and he's good for his word, there's a hold on him out of that, on you out of that Denton County. Which is a problem for you. You got to take care of that one way or the other after this. But once again, if there's a way you can get it paid through your family, the court would reward you. But if that's not something that's realistic, we got to move forward today. And I can always, if the court sentences you to confinement, then I can always change that judgment within 30 days if something happens. I can bring you back and I can change it and or whatever you might be able to get done on your behalf. But you're going to be in custody if I sentence you. You're going to be in custody for the next 30 days.
I think that's appropriate. Go ahead and do that, and then we've got, you said 30 days to try to.
On people on his behalf.
Yeah.
It's, I know you're talking about Social Security, but, I think, I can't speak for him. And, but I know sometimes government agencies can be hard to deal with, but it's also been my experience that people over believe that too. Quite often the government authorities work with people a lot easier than they thought, or people on their behalf if people on their behalf or close relatives who have proof and information of what they're doing and why they're doing, and it's in the best interest of justice, and they seem to work together when that can happen, but not always. Nothing further. I'm going to find there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 have been proven true. And did the state want to add anything else?
No, Your Honor, I've made my best argument.
And you're asking for
7 years.
And Mr. Dusler is asking to continue you on probation in some way. Again, there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 of the first amended probation have been proven true, as you have pleaded true to those voluntarily, knowingly, intelligently, and appreciating and understanding the consequences of pleading true. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 6 years. And restitution is ordered in the amount of $3,312.50 to the complainant in the indictment in this case. That will be placed in this judgment. And that's the finding of this court. If something can be done on restitution within 30 days, let me know. And we'll see what we can do about rewarding you somehow. Anything else? That is all. Thank you. Next is Mr. Calhoun, Chad Calhoun.
He's also in custody. Say. But
Hey.
Is there some probation orders for Monday? We should say the Trump.
I didn't get anything from you.
That's all.
Well,
You're saying yours, nothing? Yeah.
you actually do need him. Heard y'all got a new director.
That's what I heard too.
There's a new director.
Yes, sir.
Coming in town.
Yes, sir.
Well, we're gonna share, but we're gonna welcome Peggy.
Oh. No.
Okay. Chad Calhoun?
Yes,
Is that you, sir? And we call, cause number 20-34315, the state of Texas versus Chad Allen Calhoun, here with Mr. Dusler, your attorney and the state's attorney. There's a motion to revoke unadjudicated probation that is on file as of April 3rd, 2025. Are we going to proceed on that?
Yes, sir.
And Mr. Calhoun, raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, sir, this motion alleges that on December 16th, 2021, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is all of that true?
So, now one and two, whichever one.
One states you provided a urine sample on or about February 25th, 2025, which showed the presence of methamphetamines and amphetamine in your system. And that was in violation of number 10 of your probation order, which is do not use or possess any drug. And is that allegation true and correct as it is alleged?
It is very so.
Are you pleading true and correct voluntarily?
Yes, sir.
Because it is true.
Yes, sir.
Do you understand that a plea of true to one or more violations of probation, a voluntary and knowingly made plea, that's enough to grant the motion to revoke probation. Your probation can be revoked. You can now be found guilty, and you can be sentenced up to 2 years in the state jail. Knowing that, do you insist on pleading true?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir. Very much.
Okay. Let's see. A bit more on this, sir. An agreement has been reached here where you would be revoked, found guilty, sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked here, States Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the
Yes, sir.
competent clerk? States Exhibit 1 tendered into evidence without objection admitted. This states that all the parties, including you, understand that if I follow this agreement, you have no right of appeal. I'm going to do that. Well, let me ask one other thing. This is something I've noticed. Yeah, I guess it's under the order that states reimbursement fees. Those are probation fees. Is that what that is? That's what I've never noticed it before. Reimbursement fees. That's not restitution.
No, sir.
Okay. In the order, in the deferred bill.
You show me the I saw it.
It's entitled reimbursement fee / supervision fee, Judge.
I'm not familiar with it on the judgment, maybe if I
Okay.
saw the probation.
But it's not restitution.
No, sir. There is no recipe for this.
I'm going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading true voluntarily to a violation of your probation. You are doing that. You understand and appreciate the consequences of pleading true. That is enough to grant this motion to revoke probation. Your probation can now be revoked. I hereby revoke your unadjudicated or deferred probation that you have been on. And this motion is granted. Earlier in this case, you pleaded guilty voluntarily to the state jail felony, burglary of a building. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year. You will be given credit, of course, for all time you have served in accordance with that charge.
Yes, sir.
Do you understand what has happened today, sir?
Yes, sir.
Judge, before you pass that aside, I'd double check. There is a restitution amount on this. It is $5,000, and I know you are on that. what your typical rulings are, and I wanted to clarify my mistake.
Okay, maybe that was something, I don't know. But here in the probation order, there is restitution is owed the states in the amount of $5,000. Was anything paid on that?
He paid $572 one.
572?
Yes, sir.
So it's 572 less of,
His balance is $4,427
4428.
on restitution.
all right, restitution is hereby ordered in the amount of $4,428. That will go to the complainant in the indictment, Rodney Graddick. Do you understand what has happened to
That
that?
part, I would like you to explain, please, sir.
Huh?
That part I could use a little and I'd like to know what that means, sir, please.
That means that you still owe $4,428.
Yes,
It's in the judgment.
he would have.
And
It won't cost you more time in jail.
Yes, sir. Thank you.
But it will cost you the money.
Yes, sir.
yeah, they can,
I can.
somebody can file a civil suit now against you, and that would be and if they get the judgment, which is normally just pro forma, it shows up on things that when you try to purchase a home or get credit,
Business.
that can be used against you. But also, it was determined that was the loss, and you're getting a deal out of this. At the end of the day, that's half of what you could get, and it's at the end of the day, it's up to you. But the right thing to do is to pay people back.
Yes, sir. Very much so.
That's the right thing, and
Thank you.
maybe your conscience bothers you, like I hope most people, and you'll do something about it and fix that.
Yes, sir.
That would be the right thing to do all those, but that's your soul,
Yes, sir.
not mine. Also, anything else?
No, sir.
That is all. Thank you.
Need your right.
Yep, we need your microphone to Theodore Folly is going to be next.
Straight up and down.
I give you two more, same thing. Wait.
It's one more signature in office, sorry.
Oh, okay.
Theodore, is it Foley or Fowler's?
Well, yes.
Yes.
Oh,
Jared's still not being understood.
Say that again. Why would he be hard to locate in TDC?
I had to, like, he'd be in there and then another time grabbed him, and then by the time I did the next one, out.
He was moving around.
Yeah.
Come on up, sir. Thank you. We now call 22-41026, the state of Texas versus Theodore Lee Folly. Is that you?
Yes, sir.
Am I pronouncing it right, or is it Foley?
It's fine.
Folly. And you were here with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
yes,
So there is an indictment that's been handed up in this case as of, November of 2022. That's 2.5 years ago. And this states that on or about October 9th, 2022 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by being a convicted felon from a previous felony in 21 out of this for the 5th anniversary of your release from supervision under confinement following conviction by previously being convicted, I guess, of unauthorized use of a motor vehicle in this court. So you were convicted on April 19th of 2021, and this states that like a year and a half later or so, in October of 2022, you illegally possessed a firearm after that conviction. And so it's a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 4 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yeah.
You understand?
Yes.
Huh?
You can turn.
He wants to make sure it runs with the time he's already served in the TDC. I've explained to him.
They all run concurrent unless otherwise specified by the court in its rendering of judgment, which would be running consecutive. And I don't see that's the agreement to run consecutive, so I'm not going to say the word consecutive, which means it's going to be run concurrently.
Thank you.
And if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Now I'm guilty.
Nobody's forcing you to plead.
No.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it? Discuss it with your attorney, or the contents correct? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection admitted. The state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. An indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true and state, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes without objection.
Okay.
Pre-sentence report is way.
Yes, sir.
If nothing further to add, I'm going to make the following findings that, sir, you have pleaded guilty today voluntarily and you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now so find you guilty of this third-degree felony of unlawfully possessing a firearm after being a convicted felon. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years upon my finding you hereby guilty of this offense. Do you understand what has happened today, sir?
Yes, sir. Need a thumbprint.
Just need your thumbprint in a minute.
That's still around. Cool. Good guys. He's still around.
Yeah, I'm fine.
Same name. You know, you named after your son.
Yeah. They got him in, but he passed away. You know,
I represented him in that, so I'll let you use his son.
It's good. Straight up in this, so there are two more things and house. And so everything more something pretty good. He's a good. Some of these also good. No, very much done. Wonderful.
I'm sorry, it's so.
Thank you, sir.
Richard Gill will be next. Richard Gill.
This is a motion, no thing.
Jasmine Hall, she signed up ready for me.
Okay. Yeah, it's not on the docket, but okay, good. Okay, thank you. All right, we now call Richard Gill.
Yes, sir.
That's you, sir?
Yes, sir.
In 24 CR 1240, you were here with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke probation filed as of May 21st, 2025. In this case, are you familiar with it?
Yes, sir.
Awesome. Are we ready to proceed?
Yeah.
Mr. Dusler on his behalf. Raise your right hand, sir. Do you solemnly swear or affirm any statements that you're going to be making during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Can we proceed in summary? Does he waive a formal reading of this?
Yes.
In summary, sir, this first amended motion to revoke probation states that on October 7th, 2024, in this criminal district court, that you were sentenced to 10 years in prison, and that was suspended and probated for 10 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true, sir?
Yes. Counts, 1, 4, 8.
8 states that you committed the offense of failing to ID as a fugitive with intent to give false information on or about May 2nd, 2025 in Jefferson County, Texas, which is in violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state of the United States. Do you understand what this charges you with?
Yes, sir.
Is this true or untrue?
It's true.
Are you pleading true voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a voluntary and knowingly made plea is true to 1 or more violations of probation? That's all it takes to revoke your probation. Your probation can be now revoked and you can be sentenced to no less than 2 nor more than 10 years in prison. Do you understand?
Yes, sir.
Knowing that, do you insist on pleading true today to this violation?
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there any need to plead anything else? All right. Stand by. So originally, you entered your plea and were sentenced. This was a state jail felony of unauthorized use of a motor vehicle. However, you pleaded true back last October in this court when we placed you on probation to 2 other state jail felonies of theft, prior convictions in 2023. So thus, that's why this is called a state jail felony, but it was punished because of those prior convictions as though it were a 3rd-degree felony. You understand?
Yes.
Okay. So that's why you're facing no less than 2, no more than 10 years confinement in prison for this, even though we're calling it a state jail felony because of the 2 other prior felony convictions that were enhanced or raised the punishment level here. All right, there is no agreement?
Correct.
Go ahead, for the defense.
Well, Your Honor, he's asking the court to hold this matter in abeyance and continue on probation. This new offense occurred when he was stopped on suspicion of possession of drugs. He made a mistake by giving.
I've got it. I've got it. Yes, ma'am. Sorry.
He realizes that he made a mistake by giving false identifying information. Realized that was not a smart thing
Thank
to
you,
do
Mr. Bank.
at the time. But he feels like he can successfully complete his probation. We're not showing anything really, really bad right now. He is currently trying to rehabilitate himself from drug and alcohol use. It feels like with continued supervision from the probation department that he can successfully complete his probation. Is that correct, sir?
Yes, sir.
Is there anything else that I've not said that you want to add for the judge's benefit?
Well, Your Honor,
If it's, I would love to go to get some help.
Now?
If that's possible.
Well, have you ever been treated before, for substance abuse?
Yes. There was a lot that.
When?
So this, 2019.
I don't consider that all that long ago. Oh, well, but where was that? What was, the treatment?
Oh, this was in Dallas, Texas,
Dallas, how long were you in treatment?
for 90 days.
That's- It looks like you have a real prolific criminal history that I stuck my neck out on and granted you probation for. How many misdemeanor and felony convictions do you have?
And I said, I don't know.
What does that say? That you don't even know how many convictions you have.
Well, convictions only have two. I have two felony convictions. Those,
You swear to God on that?
yes, I only have two that I was arrested for, but there's no convictions.
I'm looking at 3 convictions here. Theft of property in Hardin County in 2017. You were placed on 4 years deferred probation for that on July 8th, 19, and another theft of property from 2018 in Hardin County, Texas. On that same date, you were placed on deferred probation in 2019 for both of those. Those were revoked in 2023, and you received 9 months state jail in each of those 2.
Yes.
Plus, this case, you were convicted of this and sentenced to 10 years in prison, and that was suspended, but it's a conviction. So you've got 3 convictions, including this one. What about your misdemeanors on what kind of? This was a unauthorized use, kind of a theft, a related theft. Do you have any other theft convictions or anything like that? Yes, you do. You got, in 2012, you committed theft in Ellis County, Texas. You were placed on 2 years deferred or unadjudicated probation for that theft in 2014. And the next year it was revoked and you were sentenced to 60 days in jail for that. Now, do you remember?
Yes, sir.
And then a misdemeanor of assault causing bodily injury to family. That was in 2015. You were placed on 12 months deferred or unadjudicated probation in 2016 for that. It does not show that that was revoked. So you must have served that out properly. Then you got a failure to identify in Tarrant County. In 2015, you were sentenced to 7 days in jail. And let's go up to 2017 in Hardin County, 2 thefts of property. In February of 2017, in the next month, you pleaded guilty and were sentenced to 40 days in jail on each of those 2. You remember those now?
Hard, the 2 in Hardin County. The only ones I remember is the ones I went to state jail for. So.
Well, it's too bad you don't remember, but the computer remembers. And then we round out the field with failure to identify. In 2019, you were placed on 1 year probation, adjudicated probation, that was revoked and you were sentenced to 88 days in jail. That was out of Hardin County. Failure to identify, 30 days in jail in 2023. And resisting arrest in 2024, you get 44 days in jail, and those were here in Jefferson County, Texas. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 convictions in courts of record, including 3 felonies. And here we are. What's state say?
Your Honor, the state, based on the defendant's criminal history, he'd been given a chance before on probation, obviously. He knew what he was supposed to do on this, and he didn't. He's got 3 new offenses while he's on probation, testing positive for cocaine. He's not reporting just about everything he can to violate his probation. The state believes the defendant should not be successful if continued on probation. We're asking for 6 years TDC.
Anything else?
No, sir, I believe. Word memoir.
Did you, Mr. Gill, this is your life. What do you want to say? Anything else you want to add? You got to fix all of this, you know. You got to start. I mean, it's in the record. So every time you commit another offense, it's piled on by these others things. These others add to the weight, and the law says it does. That's why you have to make the right choices from here on, anyway. But it's just going to get more severe for you. Was there any restitution on that?
No, Your Honor.
No. Go ahead. Anything else? Nothing?
Well, Your Honor, it all comes back to being addicted.
Yes, sir.
You know, so I can't blame nobody but myself. But you know, it's just being an addict is the hardest thing.
Yes, sir.
And I apologize to you, to my family, to everybody that I've hurt because of my addiction, but I apologize.
What do you intend to do about it, though?
So
we here in this case, we worked on with him on a substance abuse issue, didn't we?
So he was supposed to go to Franklin House, check us up every 30 days. Never went.
Okay. So we tried to help you on that, but at the end of the day, you've got to pull your own weight.
Yes.
You know, it's up to you to make the choice, and it's you to walk the walk.
Mhm.
We can only open the door of opportunity. You've got to walk through it, which you didn't do.
Yes.
Okay. But this will pass. This isn't one of those cases that that whatever I sent you on, you're going to be serving a long time. I wouldn't want to serve one day, but you'll get out. And then it's up to you to decide what direction you head in.
Yes.
And there are a lot of centers, placements that can help you, but it's got to be your choice. You made the bad choices that put you into this. You can just as easily make the right choices. It's climbing a mountain a little bit, but it's your choice.
Yes.
And you got free will. Fix it, because you seem sincere about it.
Yes.
But you gotta just don't talk the talk. Walk the walk that it takes to do the right thing and get it done. Fix that. Fix that. At the end of the day, other people aren't going to be able to do it for you. Yes, we'll make it available. It's available, but you've got to do the effort, the heavy lifting, like all of us do when we make mistakes, to fix them. Okay. I'm going to find that there is sufficient evidence supporting this first amended motion to revoke it by preponderance of the evidence or greater. As allegation 8 has been proven true, as the defendant is knowingly, voluntarily admitted, and to a violation of probation, failing to ID as a fugitive with intent to give false information. And that is enough to grant this motion to revoke probation. Thus, your probation is hereby revoked and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years, which is half of what you were sentenced to. How much credit does he have?
First branch, I'm getting about 90 days. Going back.
You're going to be given credit for all time you have served in accordance with this. We'll figure out what it is. But this is not one of those cases where you are looking at serving half time. But there will be some time that you're going to have to serve before you are released. And hopefully the prison has opportunities available inside for people with substance abuse. And they're supposed to. I understand they say they do. Take advantage of them when you can. So good luck to you. That is all. And we need his thumbprint one final time. And Quinette Henson, please. And Quinette Henson. Hey, Ryan, I don't see you on the docket. Are you got something?
It's just an add-on.
We got it added on. Okay, good deal. Thank you.
From Monday's.
It was on Monday.
Okay. Thanks.
Is it?
You're closing a lot of doors in there.
I'm gonna get Braumfield.
Do we need her first in any reason?
I can get upstairs to do my. I'll just put.
Ma'am, can you see this nice lady? Or she needs to get your thumbprint. Thank you. Okay, we now call cause number 24 CR 10, the state of Texas versus Ann Quinette Henson. Are you Miss Henson?
Yes, sir.
You are here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges in paragraph 1 that on or about November 6, 2023 in Jefferson County, Texas, you committed the offense of theft. And paragraph 2 goes on to allege that you have 5 prior theft convictions out of county courts at law of Jefferson County, Texas, and district courts from Orange County and this criminal district court of Jefferson County, Texas. So paragraphs 1 and 2 constitute a state jail felony, because even if you steal just a pack of gum, if you have 2 or more prior felony convictions or theft convictions or other felony convictions of thefts, they enhance it to an automatic state jail felony, where you're looking at no less than 180 days up to 2 years in the state jail and a fine not to exceed $10,000. So do you understand what you're charged with and the punishment range applicable?
Yes.
An agreement has been reached where you would be pleading guilty. Your sentence would be 1 year in the state jail. You'd be given credit for all time you've served. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to paragraph 1, this theft, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? And how do you plead to paragraph 2, which includes those thefts out of County Court at Law 3 on September 6th, April 20 of 2001, April 29th of 2001. That's County Court at Law number 3 of Jefferson County, Texas. And out of Orange County, this 163rd District Court of Orange County, a theft on August 12th, 2011, a felony. And then in this court, on December 20th, 2019, 2 cases of theft out of this court. Is all of that true and correct as it is alleged? And are you pleading true and correct to that voluntarily?
Yes.
I'll find this agreement of 1 year, if is made in the state jail. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
And there was no restitution in this case, Your Honor.
I'm going to show you where it's marked as State's Exhibit 1 that you need to see. Yes. First. And I want you, the defendant, to look at it. Do you recognize it? Did you discuss that with your attorney? Is everything true and correct? State's Exhibit 1 was tendered into evidence without objection to witness. Admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence reports waived. I am going to follow this agreement, ma'am, if nothing further, and find you are pleading guilty in paragraph 1 and true to the 5 allegations of convictions in paragraph 2. And you are doing that voluntarily, knowingly, intelligently. That makes a state jail felony. Punished, though, as though it were a 3rd-degree felony. So you were looking at no less than 2, no more than 10 years confinement.
No, sir.
No, I'm sorry.
It's enhanced from misdemeanors to.
I'm sorry. Yeah, it's enhanced from a misdemeanor to a state jail felony. So you were looking at no less than 180 days up to 2 years in the state jail and a fine up to $10,000. The agreement is you would be sentenced to 1 year in the state jail. I am following that. I find you guilty beyond a reasonable doubt of this state jail felony. I'm following the agreement. You were hereby sentenced to confinement in the state jail for 1 year, and you will be given credit for all time you have served in accordance with this case. You understand what's happened today, man? All right. Good luck to you.
Good luck.
John Lawry.
He is from bond. He's been sitting for short term. I guess he just sat down.
How about Ashley McKinney?
I called her name multiple times. No answer.
She's the blonde.
Oh, she just left.
I've never met her.
And it would have been Aaron Thomas.
He's in custody. We're ready to go on him.
Okay.
You want to get him out now?
Yeah.
Get his thumb check too. Thank you. Let's have some class.
Get Aaron Thomas.
You're next.
You're up next. Aaron, right?
Yes, sir.
Who's yours? Jasmine? Okay, we'll do Jasmine next after this, okay? Come on up, sir.
Can you step up here, please?
You need to Call that lady and your thumbprint, thank you. That's Kieran.
Straight up down, no small thumbprint, five like that, that's all. I noticed to get your thumbprint, yeah. Okay. Yeah, you have to put it in on the whole problem. Yeah, you do. And put it in the column. Not over it, that's good. Next to it, next to it. And then this, getting two more things on, like that thumb here and here. But just straight up. No, not that thumb, that one. Mhm. One more. No, no, thanks.
Come on over. You're here in Thomas.
Yes.
Here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading in this 24 CR 1285 indictment? Can we proceed in summary?
Yes.
In summary, this indictment, sir, alleges that on or about April 27th, 2024 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm in the direction of a habitation. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached that whatever sentence shall not exceed a cap of 5 years in prison. Is that your understanding of the agreement? Which means you're looking at no less than 2 nor more than 5 years confinement in prison. You could be sentenced to deferred or unadjudicated probation, which can be up to 10 years in length. And I think regular probation is also an option in this case where you could be sentenced up to from no less than 2 nor more than 10 years confinement in prison. That could be suspended and you could be placed on regular probation for up to 10 years. Those are 3 options. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes, sir.
How do you plead to this, guilty or not guilty? Hello?
Pleading guilty to the charge, he's asking.
Yes, sir.
Yeah, so she can hear you. How do you say it? Guilty or not guilty? Okay, we said this for trial. Go ahead.
You understand?
That's it. That's it. It's set for trial. God bless. I thought we had a deal here. You don't have a deal. The deal is,
Sit down.
no. The deal is gone. We're setting for trial. Your case, right? Come on out. Who is it? And let me see that. Yeah, I mean, this case is a year old and we're having a misunderstanding of this hearing. Come on, that's not acceptable. Anyways. Okay, who is, what's your name, ma'am?
Jason,
Jasmine Hall.
Yes, sir.
It's frozen. What's going on?
I could only get one of them.
24 CR 81 is now called. Jasmine Sade Hall,
Yes, Your Honor.
and you were here with Mr. Kimmer, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
She does right now, Your Honor.
In summary, paragraph 1 of the indictment alleges that on or about November 21st, 2023 in Jefferson County, Texas, you committed theft. And any theft, even if it's a pack of gum, if you have 2 or more prior theft convictions in a county court of law or a district court of thefts, then it is a state jail felony at least. And you have, according to this, a 2011 in paragraph 2 of 2011 county court of law conviction of Jefferson County, Texas, a theft. 2012 County Court at Law 3, Jefferson County theft conviction. February 9th, 2015, Harris County number 10 Criminal Court at Law theft conviction. November 18th, 2016, the 180th District Court of Harris County conviction of theft. August 10th of 2020, the 263rd District Court of Harris County theft. And finally, 2021, in this criminal district court, you were convicted of theft. So that's 1, 2, 3, 4, 5, 6 prior theft convictions.
I'm embarrassed.
You ought to be, if that's true. Yeah, well, you shouldn't be shocked. I mean, these are courts that should make an impact in your life. It ought to be something important to you. The fact that that you're acting amazed that you have these prior convictions, that there's no reason to suspect that these aren't true and valid. Don't act surprised. This is your life. You should know more about your life than anyone else. Anyway, you're looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, Your Honor.
An agreement's been reached. In your case, you would be pleading guilty, placed on deferred or unadjudicated probation, fined $500. Is there any restitution?
There's no restitution, Your Honor.
Looks like another case pending would be dismissed
It's her misdemeanor.
in another court. So if you're placed on deferred or unadjudicated probation, that can be up to 5 years in length. There would be terms and conditions of probation that you must follow, and I'll put you on some kind of a theft program, prevention of theft, not commission of theft, but a theft prevention program that we have with the probation office. So how do you plead here to paragraph 1, committing theft on or about November 21st, 2023 in Jefferson County, Texas, guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
And paragraph 2, those prior convictions that are here that we talked to you about out of Jefferson County and Harris County courts, are those theft convictions all true and correct as they are alleged in paragraph 2 of the indictment? And are you pleading true and correct to that voluntarily?
Yes, Your Honor.
All right.
Oh, Jasmine.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence without objection. It's admitted. Among other things, the state you are mentally competent to enter your guilty plea and the plea of truth here to this state jail felony voluntarily. You were doing this voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty in this offense. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is filed. I'm going to follow this agreement if nothing further and find you were pleading guilty today and true to paragraphs 1 and 2 respectively that constitute the state jail felony of theft. You were doing this voluntarily, knowingly, and intelligently. There's sufficient evidence supporting your guilty plea. The State's Exhibit 1 admitted here in this hearing to find you guilty beyond a reasonable doubt of the state jail felony of theft. But I'm not going to find you guilty. I'm going to defer any finding of guilty, place you on deferred or unadjudicated probation for 5 years. You get a second chance, make the most of it. You're going to be required to complete, among other things, a theft prevention program that it's very helpful. Probationers do real well after they take that. There will be other terms and conditions of probation. Make sure you follow those. Also, you're going to be fined $500. Is there any restitution?
No, Your Honor.
And there will be other terms and conditions of probation which are normal and customary for this. Make sure you follow them. If you fail, your probation could be revoked, could be found guilty, and sentenced up to 2 years in the state jail. We don't want that. Okay.
Now, if she does to decide out to you, you can talk to the judge now in our session.
Okay, give it your best shot.
Did you want to say something?
No, sir, you have to be back.
Oh, okay, okay. There's another case and it looks like that's gonna get
That's the
dismissed.
criminal insurance getting dismissed and arose out of.
Great, okay. Please see the probation office. Yes, thank you.
Is it? Reason up again?
Okay,
Mr. Thomas is confused. He wants to look at the research for him.
where were we at? Did we do James Laurie?
No, he's out here.
Where's James Laurie? Come on up, Mr. Laurie. And Ashley McKinney, that,
She's out here.
25 CR 125. We call John James Laurie, and that's you?
Yes, sir.
With Mr. Dusler, your attorney and the state's attorney. And what are we going to do today?
Yeah, this is his first appearance that I met with him. He tells me that he's in the process of talking to Buddy Reynolds about hiring him. So the court could give him 4 weeks. I think he did get close.
Okay, you are, just to make sure that you understand fully, you are charged with the state jail felony of theft of property here in paragraph 1. And that would be a state jail felony normally, carrying with it up to 2 years in the state jail, but you have 3 prior felony convictions out of, oh, there's another page. 4 listed here in the indictment, 2 on October 28th, 2009, out of burglaries of habitations out of Hardin County District Court. Thereafter, those were final, it is alleged in paragraph 3 of page 2, that you committed the felony of burglary of a habitation and were convicted in court in 2014 in clause number 20272. After that became final, you committed the felony of burglary of a habitation and were convicted another burglary and convicted of that one in the 260th District Court of Orange County, Texas. So it's my understanding the way this is pleaded, if all of this was true, you were looking at a state jail felony, but it is punished as though it were a second degree felon. So you're looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're looking at?
Yes, sir.
All right, the court has looked at this probable cause. What is the bond in this case?
I believe it's 10,000.
And now.
2,000. Looking at a public safety report, that is dated February 11th of this year. Stand by. Um, are you appointed on this?
Yes, sir. This is the first time, yeah.
So your bond is $10,000? Is that what it is, sir? Yes, sir. Okay. Okay. Um, the court is going to modify the bond in this case because the court does not trust you with this prolific criminal history. I want you to be on home confinement. You have to have a GPS device on you by the end of this day. And I want to, so I'll know where you are at all times. I don't trust you in this, looking at all of this. This is terrible.
Judge, on this.
No, I'm speaking.
Yes, sir.
You have so many convictions here. And these just aren't burglaries of anything. These are burglaries of people's homes over and over and over and over again. And the probable cause affidavit here alleges you took somebody's credit card and misused it.
It was given to me.
You know what? This is not a debate. It's what the probable cause, and you can, the grand jury indicted you based upon these facts. You're presumed innocent, but there is probable cause to believe you committed this crime based upon these facts. Okay. Here's my favorite part. In the probable cause, you told the victim here, by the way, it was $8,000, over $8,000 in charges. Boy, borrowed it for $8,000. I've never heard of such a thing. Who would trust you in for a dime? I wouldn't let you. I wouldn't give you a quarter of mine to hold. I wouldn't trust it. And what did you say here? You would pay the funds back according to this probable cause, but you never did.
Yes, sir.
Which is what the probable cause states under oath, and that is. When did you pay this back? These people.
I started paying them on May.
No. When did you pay it back? You said you paid it back. When did you pay it back?
I was making payments with them.
You haven't paid it back, have you? Completely?
Not the full amount, no.
See,
No, sir.
you're trying to take my wallet right in front of me.
No, sir.
Yes, I said, did you pay it? You said I paid it back. You haven't
Oh, no, sir,
paid
not the
it.
full amount, no, sir.
Do I have to cross-examine you to get the truth out? This is
No, sir.
terrible.
I was making payments with them.
Yeah. You are certified thief. All these convictions. And then you come up into here, I should have put you under oath because you can't even be straightforward with me right now. You're hedging in your statements. I got to correct you to get the right information. Yeah, good luck. Because all of this is admissible, which the jury can consider in evaluating your credibility at a trial. It doesn't take 6 convictions of burglaries to convince anybody that you are a dangerous person and not an honest person. And here you are, charged with that. Again, probable cause to believe that happened. All right. The end of the day, you're at home confinement. You have a GPS device. You don't leave home except for the following things: for a medical need, to get food, to go to and from work. And those are the most direct routes possible. You have to have that by the end of the day. If I don't learn that you have it on you by the end of the day, a warrant will be issued for your arrest and you will have no bond. You will sit that out until we get around to getting this case done. So I'm considering raising your bond anyway. Just for the way you handled yourself and not being forthright. Your bond ought to be 6 figures, what it ought to be. Oh, you think your criminal history and a new charge aren't worthy of that? Okay. There's a way to fix all of this, but you should have fixed it 6 convictions ago. Back to you, John.
Buddy Reynolds is representing him on a misdemeanor. He's working on hiring him, so he's trying to get money together to get Buddy hired. So we're asking 4 weeks.
Huh?
He's asking for 4 weeks.
You don't get it. You got 2 weeks. That's all. That's all you're going to get with me. I don't trust you at all. What you say to me and your prolific criminal history. We'll see if I can 2 weeks get in reset. All right. Anything else, Don?
Yes, sir.
Ashley McKinney? Ashley McKinney? Are you asking McKinney? In 25 CR 292, you are charged with the 2nd-degree felony of robbery. But it doesn't end there. You got a prior conviction. It says you were convicted in February 8th of 2022 for the 3rd-degree felony of illegal possession of a controlled substance in the 252nd District Court of Jefferson County, Texas. So if this robbery were found true beyond a reasonable doubt, then the other conviction would enhance the punishment range from what would normally be a 2nd-degree felony of robbery to a 1st-degree felony. You're looking at up to life in prison. A minimum of 5 years, up to life in prison. So you understand it's serious.
I just met her a few minutes ago for the first time, advised her how serious this matter was. She has posted a bond in the amount of $50,000, and we would suggest the court to give her some time to get an attorney hired.
Oh, where were you able to get $50,000? Because it says, according to your financial statement, that your financial statement that says you got zero money.
I've been cleaning houses since I was released this last time, and my friends came together, my family came together, and it was like 5,000, but I'm still paying on the bond. Believe that, yes, sir.
Okay.
Yeah.
Okay, what's our plan?
Give her some time to try to hire someone close in that size of the bond. She needs to be hired.
All our friends got it together. But
Yeah, we're
I'm gonna give you 3 weeks. That's all you can. Okay, get a resetting.
clearance. From this lady, she'll give you the reason.
So we're gonna test you before we leave, drug test you before you leave, okay? She's got a prior drug conviction. And we're gonna deal with that. And who do we have here?
Aaron Thomas.
Mr. Thomas, come on up.
Yes, sir. He
Come on up, Aaron.
He was
Give me that.
confused a while ago about his plea.
Okay,
We want to reassert his plea now.
okay. 24 CR 1285 is now called the State of Texas versus Aaron Joseph Thomas. Go ahead.
Yes, sir. He's entering a plea of guilty this morning, which we've signed up for. It's a count of 5 years. We're requesting deferred adjudication probation. I think that's where he was confused, where I told him if the court granted him deferred, there would be no final conviction. Do you understand you're pleading guilty this morning to the charge with a count of 5 years? You're asking the court to do a pre-sentence report, and then you can make a decision as to what's coming after that.
Right in there in the jury box. Thank you. Yeah, we'll get it for you. No, we'll get it for you. Thank you.
Not today, not today.
All right, let's go. Once again, Mr. Thomas, this is a third-degree felony. You understand the punishment range, no less than 2, no more than 10 years confinement in prison. And the agreement is a cap of 5 years in prison. We went over all those options. We're going to come back later after we get a pre-sentence report from the probation office. Everybody will then have a chance to sign on and tell me whatever you want to include in the report and what you want to add to it. Then everybody will have an argument, the state, the defense, and then I will make a decision at that time. It takes about a month or so, give or take. Is that your understanding of the plan? A cap of 5 years, and you understand what those options are? If I follow that agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead in this case, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Discuss it with your attorney, or the contents true and correct? State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1, part of the record for all purposes. All right, we're going to do a pre-sentence report. We're going to report back in about 4 weeks. And then everybody gets to add whatever information you want me to consider, and the court will make my decision. Do you understand what has happened today, sir? Mr. Thomas? Yes, you have to speak out so she can hear you. This lady can hear you. Yeah, okay. Thank you. All right, we are discussing on that. God bless you. Okay, we are in short recess and awaiting a drug test on the defendant here.
Thunder Adley Pay on behalf of Mr. Gibbons, who may be present via Zoom.
I don't think so. He is not.
Your Honor, this is on this attorney's case. I do not know whether you spoke to him. I also don't know.
Oh. Apologies, Your Honor. Good
No.
morning. This is Noble Thunder Law Attorney on behalf of Mr. Gibbons. We do not have a good number to contact Mr. Gibbons at. We did come to make contact, but we're unsuccessful.
All right, bench warrant will issue bond 5,000, 10%. Those warrants will issue immediately. Was this second one just a warrant? It was. Court does call the case of the people versus Zachary Harrington.
It should be present via Zoom. So if you're there, can you please unmute and state your name for the record? Not checked.
That's right.
Don't have an explanation to failure to appear, excuse me. I did, send an email and someone else from our office, but that, I do know he was scheduled to begin employment based on the last time I spoke with him, but to that end, I don't have an explanation for his failure to appear and respectfully request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court does call the case of the people versus Shirley Hartford. Shirley Hartford, this is Shirley. No response. Bench warrant will issue for defendant's failure to appear. How much is it?
$464.
Bond will be set in the amount of $5,000. Give a 10% privilege on that. Warrant will issue immediately. Court calls the case of the people versus Willie Henley.
Good morning, this is Public Defender Warren attorney on behalf of Mr. Henley.
And so, Willie Henley, you need to unmute and turn on your camera. You're muted, sir. I need you to state your name. Oh, there you go.
Willie Henley.
All right.
Your Honor, today's statement set for a show cause, Mr. Henley owes, I believe, $600, correct? We did, exchange some communications regarding how we can make payments. I don't have a, update for the court, Your Honor, if we did make a payment in between now and his last court date. Mr. Henley, did you make a payment?
I made a payment last night of $500. I sent you an email, the receipt.
So you paid 500 of the 600?
Yes, sir. I owe
Can you
$100.
verify that? He did pay it.
So the current balance is $100.
$100, you paid the 500? All right. When can you get that 100 paid?
By Monday, sir. Like I said before, I do it there, so I work off of tips, and if people don't tip, I just basically get $2 per order. So just give me till Monday, and I have the court the $100.
Mr. Henley, I appreciate you putting forth the effort. You paid 500 of it. I'm waiving the other 100. Your case is closed. You're good.
Thank you, sir.
You're welcome. Take care of yourself.
You too.
Court does call the case people versus Amy Karsnick.
Karsnick may be present via Zoom. She is not. So, Your Honor, I did not get a phone number for Ms. Karsnick. I did send her an email, though. The email I had on file, I don't know if that's correct or not. I did not get that. I don't have an explanation for her failure to appear in respect to the request.
You have 275.
Yes, sir.
Bench warrant will issue bond set in the amount of $3,000. 10% privilege. That warrant will issue immediately. Court does call the case of the people versus Dominic Kelly Payne.
On behalf of Mr. Kelly, who should be present via Zoom. He's not.
You think he's in custody?
I believe he might be in custody on something else. Yesterday. I did check, but that was mid-afternoon, and I did not show that he was in jail. Okay.
He was being arraigned.
Something else, yeah.
It was an in custody arraignment? All right, why don't I do this? What's my next date? June 25th, 2025, 9 a.m. I'll just adjourn it out. You guys can check where he is. Court does call the case people versus Daryl Mitz.
Good afternoon. Good morning. This is the you have of, Mr. Mix. Your Honor, we did attempt to make contact with Mr. Mix and we were unsuccessful. I, would ask for an adjournment of the show cause.
Bench warrant 5,000, 10% privilege, warrant will issue immediately. Court does call the case of the people versus Christina Morgan.
Public defender and advocate, Warden, here to be assumed. Can state your name to the court?
Christina Morgan.
Thank you, Your Honor. So I believe there's still balance owing. This morning did make a $25 payment. It was either this morning or yesterday, but when I checked this morning, she hadn't made the payment that we discussed. I understand there is still a balance. I believe she would be requesting a payment plan.
All right. What does she think she can do with regard to a payment plan monthly?
Ms. Morgan, were you requesting a $25 a month payment plan from the court?
Yes.
Is she on a fixed income or something?
Last I spoke with her, she was still seeking employment,
Got it. Okay.
but I do not know if she's yet secured.
We'll do it at this point, $25 per month. That will begin in July.
Thank you.
All right. Thank you. Court calls case, People versus Tremaine Pender.
Another case on behalf of Mr. Pinder, who's present via Zoom. Sir, can you please unmute and state your name for the court?
You keep saying all that. Hey,
So then I spoke to you, Your Honor, and he talked quite a bit about what he receives monthly, what he's doing, how he's currently not working. I do understand he still has a balance. I did expect him to be here today, or what respectfully requested here for the record. He currently owes $969. Those who receive Social Security disability was going to be asking for a $50 a month payment plan.
bench warrant 5,000, 10% privilege. Warrant will issue immediately. Thank you. Court calls case, People versus Maurice Shimwell. I think that's
Thank you, Your Honor. Assistant Public Defender Natalie, on behalf of Mr. Shemwell, who is present via Zoom, sir, please unmute, state your name for the court.
Maurice Shimwell.
Thank you, Your Honor. I have discussed Mr. Shemwell's balance with me. We had a couple of good conversations yesterday. Unfortunately, he had back surgery last fall in 2020 and is currently not working. And further, he is currently undergoing some unrelated medical testing, including having an appointment earlier this morning. Given that he's not working, he's respectfully requesting an adjournment of the show cause so he can get some of these medical things in order and figure out what's going on.
August date is.
13th.
I'll adjourn the matter to August 13th, 2025, 9 a.m. All right.
Thank you, Your Honor.
Thank you, Mr. Shimwell. Be well.
Thank you, Your Honor.
Thank you, sir. We'll be in touch before August.
Court calls case, People versus Stacy Troon. Oh, just. 981. Hello,
Hello, Your Honor.
what's your name?
Stacy Truan.
All right. Mr. Troon, you're here on a show cause. You owe $981. How are you thinking about getting that paid?
I was set off probation and, like 2.5, 3 years ago. And my probation officer told me that if I couldn't pay it because I had a slip and fall and I'm no longer working, that it would go to a collection agency. And then I get this letter saying that I got a show cause.
Right. It would go to our collections department is probably what you heard.
Okay.
And then when there's no payment in that regard, then they set it for a show cause before me.
Yeah, I just recently started receiving SSI, but I'm so far behind on all my bills. I can afford like $20 a month.
Pardon?
I can afford like $20 a month.
Why don't we do this? I'll let that happen. So we'll do $20 per month.
20 per month?
Yeah, we'll begin it in July.
Okay,
Okay? All right.
okay, thank you.
You're welcome. Take care of yourself. Court does call the case People versus Angelis Warren.
Public Defender Natalie, on behalf of Ms. Warren, maybe present via Zoom. If you're there, please unmute and state your name for the record.
Are both on.
They're both on. She's on here. Your Honor, unfortunately, all the numbers I had and then was able to locate Ms. Warren were bad. I did send her an email. I did not hear back, unfortunately. To that end, I have no explanation.
Bench warrant will issue for defendant's failure to appear in both of these matters. Bond is set in the amount of $7,500. Given 10% privilege, that warrant will issue, those warrants will issue immediately. Does recall the case of the People versus William Lynn.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lanham. Please state your name again for the record.
William Alexander Lanham.
You know what's funny? You've been here all morning, and I just keep understanding things about his parents, because I know they raised him right. And you know how I know they raised him right? It's when what's his name was coming through the gate, he got up off his seat to make sure the gate was, I mean, it sounds like a little thing, and it's a little thing to you, but you'd be surprised how that doesn't happen. And that, right there, that just goes to people being raised right. I don't know. That, I just sometimes get amazed. Go ahead. All right. Where are we?
Your Honor, we did have a bench conference regarding this matter, and the court indicated we will be ordering 4 days. We did communicate regarding a date. I did speak to probation regarding the date, and it seems like she doesn't have a problem with it. It would be July 10th, which is a Thursday. I'd ask if he could report like at 6 p.m.
July 10th. Okay, gotcha.
And then, yeah, around 6 after the workday, and then do serve his 4 days and be out on the weekend. Actually, Your Honor, one more request. He's asking for a little bit later in the day, if that's allowed. He suggested like 8 or 9, 10.
What's the latest they like to report there? You know, just change it. Yeah, I think that's probably late. The
7's the latest.
Yeah.
Yeah, I know sometimes it can take a while to get booked in, and you want to get booked before midnight.
I'm going to order July 10th, 2025 at 7 p.m. to serve his 4 days. All right. We'll just have to do it that way.
If anything, major comes up, is it okay to change the date? With talking.
I'm going to say no. I'm going to say if there's something major that comes up, contact your attorney and then we'll figure it out maybe.
Yes, Your Honor.
But right now it'll be set for July 10th at 7 p.m.
Yes.
All right.
Thank you.
Okay. Thank you. Mom and Dad, thank you so much for coming down and supporting him. All right.
Thank you.
Yes, thank you. All right. You guys take care of yourselves. Okay, yeah. Thank you again. Thank you. Is that it for us for today? 14A. Stands adjourned.
Your name, ma'am?
Yes, well,
All right, do you have this money to pay on this?
yes, sir, I'm ready to pay, but I have requested that car needed repair, that's why I could not move.
Slow down. You have, this ticket was issued in February. Do you have the money to pay this ticket?
Yes.
What were you starting to tell me? I didn't understand. You keep your voice up nice and loud.
So the car needed the repair. And so without repair, it could not be moved. So I had to go to the mechanic shop.
When did you do that?
That's a few days, because I had to get the AAA after a few days of that ticket.
I tell you what. You didn't show up. Next time you need to show up and talk to people. You didn't show up. I'm just gonna reduce your fines for you, okay? All right, we'll just reduce the fines. Fines cost reduced to $75. Go down and pay that. Show cause dismissed, okay? So $75. You can live with that, right? Do you understand, sir?
Yes, sir.
I'm just gonna charge you $75. It's $213 now,
Okay, sir.
okay? So go down and pay your $75 and you're all set. Good luck. Mark Austin? Mark Charles John Austin, 242-643-179. Your name?
Mark Austin.
Mr. Austin. You're supposed to pay 25 per week. How much have you paid on this?
This is the first piece of information or paperwork that I received after being released from jail. I wasn't aware that I was supposed to, or how, if I was supposed to pay anything or who I was supposed to pay it to.
You have to pay 25 per week is what I ordered, starting May 23.
Right. Yeah, I was unaware of that. They just released me and they didn't give me any type of, any sort of paperwork or any.
All right.
I was completely unnotified, unaware of that.
So I'll give you time to pay. How's that?
I would love that. Submitted.
When can you make your first payment?
When, I have some money on me right now. It's not $25.
How much do you have? Don't worry about it. Listen, put your wallet away. Just tell me when you can start to pay $25 a week.
Within a few weeks.
Well, I don't know what that means.
If I'm being honest, my mom is in the hospital right now. She can't work. She's pretty much bedridden. My father's not there, and the bank is about to take the house, so I'm kind of concerned with that.
Of course you should be. I'll tell you what. I'm gonna extend your time to pay. I'm gonna let you start to pay this on July the 11th.
July the 11th.
Are you working?
I am here.
Where?
I work, it's a company, it's called Gentech. It's my stepfather's friend.
How often do you work?
It's usually 3-4 days a week.
How much do you make?
15 an hour.
All right, maybe you need to get a second job. You start to pay 25 per week starting July the 11th, okay?
Where do I make that payment to? Is there a website or something?
You can go on 33court.com, but there's a fee on that here. Or you can bring it up here,
Okay.
okay?
Sounds good.
All right, good luck.
Thank you.
If you need more time, come talk to me, okay? On or before your due date. Hunter, Tiffany N. Hunter, 25 F243648. Your name, ma'am?
Tiffany Hunter.
Okay, how much what are you asking for here?
I made an arrangement.
Yeah, I understand. Tell me how much you can pay.
If I could do like 20 or 25, a month, every couple weeks.
Do you work?
I do. I'm a single mom of 3 kids.
Where do you work?
At the Meyer gas station. I've been there for 11 years.
I mean, you're kind of asking for a lot. 20, if this would take you 10 months.
30.
Alright. Okay. 30 per month beginning
I mean,
July.
when I can pay more, I will. the payments will be made.
30 per month beginning July 1. If you need more time, you come talk to me. If you don't have the money, just come talk to me on or before the due date, okay?
Thank you so much.
All right, best of luck. Thank you. Ayesha Abdulwasa Ali. 25-837-166. Your name, ma'am?
Aisha.
Good morning. You're charged with the parental responsibility violation. You have the right to a lawyer. Would you like a lawyer?
No.
So they think that you didn't send your child to school, your child Isa Kataya at 24825 Hall Road in the city of Woodhaven on or about May the 26th to 25 at 1:49 p.m. So they think the child's missing days regularly.
Well.
Hang on.
Sorry.
So that is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs of all those. Do you understand that?
I understand.
Did you sign the advice of rights?
Yes.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
Again, you have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea for you. I'm gonna give you a personal bond. Here are your bond conditions you have to comply with. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're to ensure that your child attends school regularly. The only time the child should be missing school is if the child is ill. You go talk to the prosecutor, see if you can work something out. And this will be the city of Woodhaven prosecutor, so you can go right out in the hallway. He'll bring the file to the prosecutor and then he'll call you in, okay? Good luck, thanks.
They got a sick feel, I mean, the fan just showed up.
Okay. Jackson Farrell. 23B82267, 23B76671, and 24B82280. Good morning.
Good morning, Your Honor. Attorney Christopher Bogart on behalf of Mr. Jackson Farrell, who is present via Zoom.
Hey, guy, sir. Yeah. Okay. Mr. Farrell, your name?
Jackson Farrell.
All right, so he's got a contempt charge for failure to pay $213, another contempt charge for failure to pay $207. That's from 2023. He's never been arraigned on this anti-blight case. So let's start with that. For that purpose, does he stand mute and waive formal reading?
Yes, Your Honor.
So I'm gonna enter a not guilty plea. Why hasn't he been here?
Your Honor, it's my understanding that Mr. Farrell is completely disabled. He is blind. He's also in a wheelchair for most of the part, so mobility is an extreme issue. That is why he is appearing via Zoom here today. I don't believe, based off my conversations with Mr. Farrell and then also with the prosecution, I truly don't believe that Mr. Farrell had an understanding of the severity of the cases and the charges that were being presented against him. When I did speak to Mr. Farrell, he then came to the realization and conclusion that he obviously should have appeared way back when. I just think with his disabilities and the lack of understanding, I think is the main reason why he wasn't able to appear here today or appear previous to today's hearing, Your Honor.
Sir, you have to show up in court. You understand that, right?
Yes, I was never notified, Your Honor. I moved out from Brownstown 2015, and there has been no notices. Other people in my family that live in the Brownstown house haven't seen any notices.
Wait a minute, let's slow down a second. Does he not own the property at 22341 Donnelly?
He does, Your Honor. He just lives at a different address now.
Well, who lives there now? Did you write a forwarding address? You have a forwarding address with the postal service?
We moved out to Adrian in 2015. The post office would have had it, but.
How did you find out about these cases?
Your Honor, the city of Brownstown filed a civil complaint against Mr. Farrell in order to force the cleanup of the property. He was eventually served with that. That's how he found out about all these other issues and then contacted our office for representation. When I sat down with Mr. Farrell and looked up his cases, that's when I learned that he had quite a few cases that were outstanding with this court between Your Honor and also Judge Henson as well, who we're going to go in front of after appearing here on the record, Your Honor. I did speak with the Brownstown prosecutors. My understanding that Mr. Farrell has been in the process of cleaning out the property since then. It's my understanding that a lot of the property has been cleaned up. Prosecution wants to be able to adjourn this matter so that way we can get a future court date to make sure that Mr. Farrell is in compliance, and then also working out a resolution in the civil case as well, Your Honor.
I'd like to see him pay these 2 civil infractions. They've been outstanding for 2 years.
Yeah, I understand that, Your Honor. Mr. Farrell only receives a limited amount of money each month. He is aware that there's outstanding balances that will need to be paid. We are asking the court to allow us to be able to work out a resolution with the prosecutor so that way he'll know his total complete balance with this court, Your Honor.
You gotta get the property cleaned up, sir.
Yes, sir, that's what I'm working on.
Like quickly, because I'm not gonna be very patient on this. This is 2023 and 2024 incidents in front of me. I'll set a new court date. I'll adjourn the show causes on the civil infractions. I'll enter a not guilty plea on the misdemeanor. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I'm gonna give you a court date, and that will be for a pretrial on the misdemeanor of
July 16th at 8:30.
So counsel, I'm gonna do that, but he's gotta have to have that property cleaned up.
Thank you, Your Honor.
And if it's not cleaned up, I'm setting for jury or bench, whatever you want, okay?
Thank you, Your Honor.
All right, so I'll adjourn those 2 other cases to the same date, so we'll take care of the civil infractions at the same time.
Thank you, Your Honor.
And we'll go from there. Anything else?
Not at this time, Your Honor.
Have a good day. Thanks. People against Langley. Spencer Charles Langley. 5B148483. Your name, sir?
Spencer Langley. Spencer Langley.
Okay, officer, your name?
Officer Gaten, Harlan, Brownstown Township Police Department.
Okay, why don't you, you don't have to be that close to the microphone. Get in front of the podium, sir. All right, so you're charged with a stop sign violation.
Yeah.
How bad's his record? It's not good, is it?
He has some moving violations within the last few years, Your Honor. I got a few things written down.
So he's got at least, yeah. What do you want to do on this? So he's got 3 violations plus this one.
Yeah, after speaking to him, Your Honor, real quick, he showed me some photos where there's a branch hanging down slightly in front of the stop sign. I do not believe it is enough to go ahead and in broad daylight miss this stop sign. I do want to bring that to your attention.
Hang on a second. I don't want to have a hearing unless we don't reach a resolution.
We never had a chance to talk, Your Honor.
Oh, you guys haven't?
Negative, nope.
Well, let me just ask you this. He's got 3 priors. Can you look him up on there, Amy?
I have a certified driving history if you want, Your Honor, right here. Am I supposed?
Yeah, he's got 3 prior violations, right?
Yes, Your Honor.
I mean, I don't have a problem with you offering him impeding if you want to do that.
Impeding?
If you-
You're okay with that, Your
if you
Honor?
want to.
I will offer.
On a 4th, this is his last one though. You want to plead to impeding traffic? Hang on. Wait. Let me finish.
I'm so sorry, Your Honor.
If you want to plead to impeding.
Everybody tomorrow. You're signing off.
Nothing further, Your Honor.
Okay, that's it then.
All right.
I'm gonna come see you in the jail to explain. You have to sit in county jail, basically.
All rise.
Seated. All right, this is 24-127, Darrell Grady, violation of community control. Final hearing violation, tested positive for cocaine, March 27. You understand that charge?
Yes, sir.
And also tested positive for cocaine on May 1. Do you understand that charge?
Yes, sir.
All right, Mr. Watson.
Thank you, Your Honor. May it please the court, we're here this morning for a final probation violation hearing. I have talked to Mr. Grady. He is prepared to waive his final hearing and enter a plea of guilty to the violations and proceed straight to sentencing, Your Honor. Thank you.
Okay, is that what you want to do, Mr. Grady?
Yes, sir. I'd like to go to a treatment.
All right, hold on. What's your plea to the violation?
Oh, yeah, guilty.
All right.
Yes.
All right, I'll accept your guilty plea and find you guilty. Go ahead.
Yeah, if, with your permission, I would like to go to in treatment, outside treatment, if possible.
You ever had treatment before?
We did JTP here, but
how'd that go?
Oh, I passed. I got a certified certificate, but they also told me I had post-traumatic disorders, which I have too much no understanding. I wanted to find out how that affect me.
Did you get a mental health evaluation?
Yes, that came up in my mental health evaluation.
Who did that? What agency did that?
I think they did it. They did it here, didn't they? I think they did it here.
Was it Signature Health?
Yeah, my.
He was going through Renaissance.
Oh, yeah, Renaissance.
Where's Renaissance?
It's in Cleveland, off of Euclid.
What did they tell you to do when they gave you that evaluation?
Well, they was just starting up a new program that was gonna come up soon. They was gonna start a new program, but I could have came
every Thursday was my probation day, but, they was gonna start a new program, get started up. But the thing about that, my probation officer and Renaissance, I think it was difference of understanding what I really actually needed. They wanted some type of treatment plan or something like that, my probation officer. And the Renaissance, they was saying that they didn't offer that or something like that. How did they word that? Could I ask her? How they?
Renaissance is a mental behavioral health center. It helps you with your mental disability. The understanding was they thought it was a drug treatment center, and it's not. It's very helpful for his mental status, which he has a lot of medication at home that he has to take.
Okay.
Yeah, they had put me on the medication that I'm taking.
What medication, do you remember?
Anterol, and
I can't remember it.
I can't pronounce it.
All
Anterol.
his medicine at home. But he haven't taken his medicine since he's been in.
All right. Okay, Mr. Watson?
Thank you, Your Honor. May it please the court, I'll be brief. Mr. Grady, I think, is a good person at heart, but obviously he's got a bit of a drug problem, and I think he would benefit through an inpatient program, hopefully giving him some tools so when he completes it and when he gets out, which I'm sure he will, he can remain sober. I know in chambers we talked about Lake Geauga. Although it's a bit vague, they did say they would make a bed available for him if the court would consider it. I did bring this up to the probation officer. The family is here. I'm going to bring it up to the court because the family brought in paperwork, Your Honor, but they also, the family, not my office, Your Honor, but the family reached out to Ethan's Crossings, I believe in Euclid, Ohio, and they also indicated that they would be able to accept Mr. Grady on an inpatient basis. But regardless of where the court will consider, I'm going to respectfully ask the court to please consider continuing him on probation, give him an opportunity to go to a treatment program, and let him show the court that he can complete it and remain sober. Thank you, Your Honor.
All right. All right, I'm going to keep you on community control. We don't know the time frame of Concord or Lake, right?
Unfortunately, Your Honor, no. I'm going to assume if the court were to give 30 days and suspend when the bed's available, I believe that would be sufficient time.
I would think so as well, Your Honor, 30 additional days.
All right. All right, so I'm going to give you 65 days in jail with credit for 35. As soon as a bed is available at either Lake House or Concord Pines, you'll be taken there, and the remainder of the days will be suspended. So you're going to complete that program and follow their recommendations. Continue your mental health treatment in whatever variety it is with Renaissance, okay? And you need to take your medication as is prescribed by them, okay?
All right.
And sign releases for probation, and all the other terms that I put in effect last fall still stay in effect.
All right.
So, any questions?
No, sir.
Okay. Anything else, Mr. Watson?
Nothing further, Your Honor.
Okay, that's it then.
All right.
I'm going to come see you in the jail to explain. You have to sit in county jail, basically.
Charge of resisting an officer that you pled guilty.
We're at DOC headquarters in Baton Rouge, and I'd like to get the folks, staff here at headquarters to introduce yourself for the record. Sure.
Francis Abbott.
Oh, thank you. And our first location is at Bossier, maximum security. And I think we have Mr. Hall with us. Mr. Hall, is there any staff member in that room with you?
No, ma'am.
Okay, so you're by yourself. We'll go ahead and proceed. Let me ask you to introduce yourself. Tell us your name and DOC number.
Delaney Marquis Hall, DOC number 711477.
All right, thank you, sir. And we have joining us by Zoom, we have Carl Gilliard, the New Start Organization, and Pastor Elvis English, both who want to speak on your behalf, and we'll ask them to do that at the first phone. Do you have any paperwork there with you?
Yes, ma'am. They gave me a parole revocation questionnaire.
Okay, good. That's what I'm looking for. Is that your signature at the bottom of that page, sir?
Yes, ma'am.
Based on your answers to those questions, it was determined you're not eligible for appointed counsel. So are you ready to proceed this morning without a lawyer?
Yes, ma'am.
All right. Your case has been assigned to Mr. Barra, so I'm going to just turn it over to him.
Yes, ma'am.
Mr. Hall, it's alleged that you have violated in the following manners. Condition number 2, that you failed to submit a monthly report as instructed by your parole officer for the months of September through December of 22, January of 23, March through July of 23, September through December of 23, January of 24, and March through present of 24. How do you plead to that?
Not guilty. Me and my parole officer would come and see me, and I worked 90 to 100 hours a week, and he would video call me, sometimes, or he would come by the house and see me. I don't know if that matters, but anytime he needed to see me, he would call me and he would say, "Hey, I need you to come in," and I would come in whenever he would call me and tell me that I needed to come by.
Okay, well, according to the summary of the preliminary hearing, that's not quite how it went, but it doesn't say for you to do a video call with him. It says you submit monthly and you turn in a report. Did you go in monthly and turn in a report?
Not every month. No, sir.
All right. The next violation is violation number 4. On or about June 22nd, 2024, you committed the offense of possession of Schedule 2 drugs, possession of Schedule 1 drugs, illegal carrying of a weapon, aggravated flight from an officer, and other traffic violations. You were billed at 26th Judicial District Court, charging you on or about June 22nd, 24, that you did lawfully possess a firearm or carry a concealed weapon, namely a black automatic Colt pistol M1911, serial number, and a black Taurus pistol with a serial number of, after having been previously convicted of possession with intent to distribute Schedule 1. Court minutes from the 26th Judicial dated April 28, 25. So on that date, the bill charge of possession of a firearm or concealed weapon was amended to the charge of illegal carrying of a weapon, and that you pled guilty to the amended charge and was sentenced to serve 6 months in the parish jail with credit for time served. How do you plead to that violation?
Guilty.
Also, another violation of condition number 4. Court minutes from the 26th Judicial District dated April 28, 25. On that date, bill charge of aggravated flight from an officer where human life was endangered, and being amended to charge of resisting an officer, that you pled guilty to amended charge and was sentenced to serve 6 months in the parish jail with credit for time served. How do you plead to that violation?
Yes, I pled guilty to a regular flight, but I wasn't actually running from the cop. We were out in the middle of nowhere, and I actually had the cop riding right behind me, and I was telling him that I wanted to stop at a public destination.
But you did plead guilty to the charge.
Yes, sir.
Okay. You also have a violation of condition number 5. On or about June 22nd, 24, you committed the offense of illegal carrying of a weapon. Court minutes from 626 Judicial Court bill the charge of possession of a firearm or carrying of a concealed weapon by a convicted felon and being amended to the charge of illegal carrying of a weapon. You pled guilty to that amended charge and was ordered to serve 6 months in the parish jail. How do you plead to that, Father?
Yes, sir. I pled guilty, but I had no knowledge of the weapons. Being that we had affidavits wrote, that I didn't have knowledge of it, but I know it was still in possession, so I took the charge.
Right. Condition number 10, you failed to make monthly supervision fee payments as instructed by your parole officer, and you were in arrears of supervision fee of $1,260, and your last payment was on October 14th of 2022. How do you plead to that?
Guilty.
Okay. I have a question about that. When you said earlier you're working 100 hours at a time and you didn't make any payments to your supervision fee, why was that?
Yes, I was making payments, but then I got laid off and stuff. That's why I recently got a new job and stuff, and child support and divorce and stuff like that I was going through. I didn't get back into paying it, but I did let my parole officer know that I was going to pay it. I actually was working to paying it all in full.
Right. I don't have any further questions. Do any of my colleagues, do they have any questions?
I don't have any questions. I don't either.
No questions.
So let's see if, is Mr. Gilliard on with us? No. Weren't able to get him. What about Mr. English?
English on the phone, he's trying to log in.
Yeah, let's talk on the phone. We have, Mr. English, Elvis English, by phone.
Hold on, listen, hey, listen to me. We're just gonna put you on the speakerphone in front of the board members, so they're gonna ask you for your statement here now. Go ahead.
Go ahead, Mr. English.
Mr. English, you're asked, make your statement.
Yes, I'm here.
Okay, what would you like us to know about Mr. Hall?
He is a fine young gentleman. He is my musician at the church. He is a hard worker. He is just a great guy. Just kind of got in a bad situation, and he deserves another chance. And can you hear me now? Can you see? I'm on now.
We don't see you, but we can hear you fine on the phone.
Okay, all right.
All right, well, thank you, sir. We appreciate your comment.
And also, I have a job waiting for him when he gets out.
Okay, great. Thank you, sir.
All right.
All right, again, we were not able to get Mr. Gilliard with the New Start organization, so I don't see any other questions. I do believe that the board is prepared to vote. Mr. Folly?
Mr. Hall, you leave me with no choice but to vote to revoke your parole with the possession of the firearm and the convictions for those charges of the firearm. That's pretty much the most serious violation you can commit while you're on parole, short of a more serious crime. So my vote today is to revoke based on possession of firearm while on supervision.
I concur, Mr. Balron. My vote, Mr. Hall, also is to revoke for the possession of the firearm. I find to be violating condition number 4 of your parole. So today, sir, it's a unanimous vote that parole's being revoked. Good luck to you, sir. You'll be able to reapply again for another parole, for re-parole, and we'll send you some information on how to do that. Good luck to you, sir.
Okay, thank you.
Good morning. Committee on Parole is reconvening. We're now at Allen Correctional Center on Wednesday, June 11th, 2025. My name is Cheryl Renatza, serving as chair today. My colleagues on the panel, to my left is Mr. Danny Ballard, to my right is Mrs. Stapleton. Remote location at this time is at Allen Correctional Center. With the staff at Allen, please introduce yourself for the record.
Good morning. I'm Deputy Warden Brent Thompson.
Good morning, Assistant Warden Crystal Simon.
Good morning, Jessica Manual Classifications. All right, thank you for accommodating us this morning. And we have Mr. Howard there in front of us. Mr. Howard, would you introduce yourself? Tell us your name and DOC number, please.
My name is Kentrell Howard, DOC number 448329.
Yes, sir, Mr. Howard. Let me acknowledge the folks who have joined us here in Baton Rouge that are here in support of your parole request. We have family members, Lakeisha Stafford, Ophelia Howard, Kentronika Francis, Sharon DeVille, Keandre Stafford, and Kalasia Stafford. And also in support is Jerome Boykin. Mr. Boykin and Kalasia will be speaking on your behalf, and we'll ask them for their remarks shortly. First, let me just read some identifying information into the record, and then we want to hear your statement. So, Mr. Howard, you're classified as a third felony offender. You're currently serving a 30-year sentence, sentenced in Terrebonne Parish in 2017. Possession with intent to distribute cocaine as a habitual offender. Your parole eligibility, has passed. It was July 24th, 2023. You have a good time date, which is January 30th, 2045. Is all that information correct, sir?
Yes, ma'am.
So I see that where this is a rehearing, you had a parole hearing in the past. So we do it a little different now. We want to hear your statement first. We want you to tell us why are you in jail and why do you think we should vote favorably for you today?
Yes, ma'am. Well, I feel the parole board should grant me parole because I suffered and I learned my lesson over these 9.5 years. And I've been doing what I was supposed to do in prison, trying to, better myself. And I've been doing it. And I understand the people that I hurt selling drugs. I hurt people and their family. And I also hurt myself and my family who had DOC headquarters. And I just want to apologize for my foolish actions.
All right. Well, let's ask Warden Thompson, what can you tell us about Mr. Howard?
Howard and I spoke on yesterday. I can say he's doing well as far as his dictionary is concerned. He had a write-up in approximately 3 years. And that's pretty good. But I also told him on yesterday that I encourage him to get finished with his GED. That's something that he really actually gonna need to help him when he gets to society. They won't repeat after coming back into the system. And I also told him on yesterday too, I think something that's gonna help him out a lot. We have a program here called the Boys and Men program, which is a 6-tier class that these guys will actually take upon completion. I think it'll be something very essential for him to have and get completed so they help him actually stay out in society if he actually do make it to parole board here in the near future.
How long is that program?
It's 6 months. It's 6 months. Yes, it's 6 tiers per month. But it's a very, very effective program. You have a lot of inmates on the backlog that's want to get involved in it, but it's very, very, very good for these inmates. A lot of them like it and have some good classes that's being taught in there as far as recidivism, male and female relationships. But I think there'll be something good for him.
All right, good. Thank you. Thank you, sir. All right, we'll hear from the folks who want to speak on behalf of Mr. Howard. First, we'd like to hear from his daughter, Kalasia. If you'd step up to the podium, please.
Hi, I'm Folly. The last time I see my father was when I was 13, so I'm now feeling, trying to build upon resilience over, he's been doing a great job. We spent 9 years, this is really hard, building upon, I'm so proud of him, the things that he talked to me about, the things that he wants to be, and I'm really mindful. All the things, the plans, the things that he told me to research for him to better himself. All of the times he would call me back to back so we could complete our conversation. He wants to know about this program. Is there anything that he could bring to y'all's attention that he can try, to come home? And he's a completely different man. Before he was incarcerated, our bond, it wasn't that strong. But to call every day, constantly, all day, and we sit there and get to actually through a jail phone, that means everything. And I know for a fact, I believe he's gonna come home and he's gonna do it.
Thank you. All right, and, Jerome Boykin, please.
Good morning.
Morning.
My name is Jerome Boyd, retired captain with the Tiddle Sheriff's Office. I'm also president of the local NAACP and Moments. I'm here today in support of this power being parole for several reasons. One reason is I know he have changed. And the reason why I know he have changed because I spoke to him by phone when he first went to prison. Up until now, him and I have been conversating. I've noticed the change when he first went there, and after he changed, I know he have changed. He's been incarcerated for almost 10 years. And if you look at his record, then he have a few minor infractions, probably less than 7 or 8 in almost 10 years. I don't feel that Mr. Howard is a threat to society. Although I don't condone drugs, using drugs or selling drugs. But however, I think he have done his time. He have proved that he can live in society. And I think he is a better person now that he has spent almost 10 years in prison. I own a company, JB Sweeping Service. It won't be a problem in employment. Also a consultant for Senator Mike Fazek belongs to PCM. It's a pipeline company. It won't be a problem finding there. So this option for employment is probably better than most. I would have 3 or 4 options of getting a job once he is released from prison. I know he was tried as a habitual offender, so I went back in the record to try to see when it came to the drugs. And I think all of the charges that he had, it was probably less than $1,500 for the drugs. So this is not someone who is in here. He's a user and a seller. But I think he earned the right to be released back in society. I have approximately 10 or 12 inmates, some that committed murder that I have been working with since they have been released from prison. And so far, I can honestly say to you all, no one has been arrested or put back in jail or prison. And I'm asking you to send him back so I can work with him. Thank you.
Sure. And, Shanika Smith, please.
Morning, that's all because we, in his whole time in Costa Rica, we have been talking. I see a change. I know he's changed. He's ready to come home to his family. We're here to support him, willing to pay his parole fees up to 6 to 9 months of his fees. when he come home, we have an extra vehicle that he can use to get back and forth to work while he's out there trying to get himself together. And I'm just saying that I know he's a changed man, and I think he needs to come home with family. Thank you.
Thank you. All right, Mr. Howard, your case was assigned to Mrs. Stapleton. Would you answer her questions? Good morning, Mr. Howard. What in your words do you find? I know what you were arrested for. I know that that you ran in the house that you ran into. They found a gun in it. Am I correct?
That was a case that I was never convicted of that particular charge. It was the charge with me and Laura Durkin that got stopped. That's where they found drugs at.
Uh-huh. And did you run?
Yes, ma'am.
Did you run to a house?
No, I was found I was picked when I was arrested. I was arrested at a house, but I had warrants for a drug charge.
Right. And when I read this report, it says when they went into the house, there was a Glock model 22 and a 40 caliber handgun that was retrieved in the house. And a bag of suspected crack cocaine in the door handle of the vehicle that you were driving. You were later charged with the simple criminal damage to property of over $500. So,
yes, ma'am.
Did you know anything about the gun in the house? Two guns.
I didn't. The house. I didn't live at the house. I never seen the gun, but
You
the
just
drugs
ran out the person.
Is a girl that I knew. They had the gun in the house, but the drugs that was in the car, I know about the drugs.
Okay.
Drugs.
I noticed that on the last hearing in 23, they had suggested that you take certain classes. And what I did notice is that you've taken those classes. Tell me all the classes that you've taken, sir.
I have taken Thanking for a Change. I have taken Victim Impact. I have taken Living in Balance Phase 1 and 2. Since my last hearing, when I went to my last hearing, I had no subjects completed for my GED, but now I have 4 subjects. I just have 1 subject left and I will have my GED.
Okay.
And if your parole board was to grant me parole, I was wondering, could I get a special condition to take this last subject? I just have 1 subject left.
Okay.
And I have Man in the Mirror. I have 2 NAAs. I got a lot of certificates I can't remember.
Yeah, I'm seeing all of that, and that's very commendable. What they told you to do, you got busy with it. I noticed that your disciplinary reports, I only see 2 here. Is that correct?
Yes, ma'am.
Yeah, so that's, like they said, that's not a problem either. And then, of course, I see that you successfully participated in the substance abuse program. So that's another one that was very important. It says you're eligible for the transitional work program. Do you work outside of the jail, prison?
No, ma'am.
No? Okay. The warden was talking about an interesting class. What do you think about that?
For my last hearing,
I
had to vote, and I was granted by two parole members, Ms. Pearl Wise and Mr. Andrew Marbella, and I was denied by Mr. Pete Freeman. Mr. Pete Freeman recommended that I needed living in balance and victim impact, and I never knew anything about the other classes.
Okay. Yeah, I see where you accomplished everything they asked you to accomplish. You got a 30-year sentence, and of that, you've just a little bit short of serving 1/3 of a 30-year sentence.
And I'm kind of concerned about that. You have opposition from the DA and the sheriff's office. That's the opposition. Anybody else have questions?
Yeah, you had 4 periods of supervision already, and 3 of them got revoked out of them 4. What will be different this time? What have you learned? Why would it be different, you know? 4 was a chunk, 3 out. You know, that's what I'm trying to figure out. That's my problem with it.
I was a little younger back then. Now I'm mature. My prior convictions, I was always getting slaps on the wrist, and I never served a long time in jail. And this time, I got a 30-year sentence. I've been incarcerated going on 10 years, and I definitely learned my lesson. And I'm just waiting on the time to prove myself to the parole board, my family, Mr. Jerome Borkin, and people in society that I'm a changed man.
That's the only question.
So let me ask you this. Your daughter mentioned that she was excited about your plans. What are your plans?
I plan to get out here and work instead of going back to the old life and be there with my family. Because I have 5 kids. I have three baby mothers. Before I got incarcerated, my children, they weren't familiar with each other. But since I've been in here, all of them, they together now, and I'm the only one that's missing.
That's pretty good incentive.
I just waiting on the opportunity to prove myself.
So we talked about, you told Ms. Stapleton about all the programs you took. What was the one that you got the most out of and why?
Thank you for a change. Thank you for a change. Because before I react to things, I think about it. I don't let my reactions override my thinking. And that's how I stayed out of trouble all the time in jail. I have 2 write-ups, and if I feel if I didn't take that class, I probably would have more, because I ran into many situations where I backed down from fights because I didn't want to get into trouble.
Well, you are to be commended for your disciplinary record. You're right. It's 2 write-ups, and they were both within about 3 months of each other in 2022, and you've done really well since then. So you're to be commended for that. I don't have any other questions. Are you ready to vote?
I wanted to ask also, you were talking about with Ms. Renasa about your plans, and I heard Mr. Boykin talking about you coming to work for him. Have y'all discussed that? I know he discussed it with us now. Have y'all discussed it?
Yes, ma'am.
Is that something you're interested in doing?
I asked him.
You asked him?
I asked him. And
Yes.
over the years, I looked up to Mr. Jerome because he's a positive person. And
yes.
I bothered him a lot, called him a lot, and he was gonna give me a job. I had 1 subject for my GED.
What's that subject?
Language.
Language. Okay. I'll go to executive session. We have a motion by Mrs. Stapleton for executive session.
Second.
Second by Mr. Byron. You call it on.
Renata?
Yes.
Stapleton?
Yes.
Byron?
Okay. All right. We'll be in executive session for just a moment to discuss confidential matters. Stand by.
About time and so you do something like this, because I can look at that. So at least half the time. You've been down for 9 years. Thank you for being paid all your work and GED. Everything else that
That's what I was saying, with the GED.
Regular session, Mr. Howard, and we are prepared to vote. Mrs. Stapleton will be voting first.
Mr. Howard, today I'm going to vote to grant with conditions that you complete the Boys to Men program and, your GED.
Mr. Barra.
I'm also gonna vote to grant with the special condition that you have a curfew of 10 p.m. to 6 a.m. for the first year of supervision, unless you have a job that requires you to work during those hours, and that you also complete outpatient substance abuse following up on whatever is recommended from the programs that you'll be attending before that. So in other words, follow all recommendations from any substance use providers that you're involved with.
All right, Mr. Howard, you were asked to do some programs at your last hearing. You completed that. You've got a good conduct record. The warden spoke highly of your record and has made some really good recommendations. So my vote today also is to grant, but after you complete that Boys to Men program, still working on your GED. Now we want you to get your GED. If you're not able to obtain that before you finish the Boys to Men, you still work on it when you get out. You got to get it. And then the curfew and the substance abuse follow-up that Mr. Byron mentioned. Do you understand all that?
Yes, ma'am.
You got a little more work to do, but you're on the right track. Good luck to you, sir.
And don't forget, you got 20 years if you mess up any of those special conditions, so you still got a lot of time hanging over your head as an incentive, and no guns, and not around anybody who handles guns. You get caught with a guy with a gun is just as bad as if you got caught with the gun yourself.
Yes, sir. I have one question.
You might have to change a couple of people, places, and things that you were used to.
Yes, sir.
What's your question?
I have one question, like, taking the last subjects, I'm not real good with school. I failed like a couple times trying to get these subjects. So you basically telling me like if I don't been pass the test by the time I finish Boys to Men, I could take it in society.
Go work on it outside.
Yes, ma'am.
All right? And you got a lot of people in this room that'll help you with that language that you need. So good luck to you. All right.
Thank you.
my lead. Or a good man will lead you on. I'm gonna do you. We'll get you in, I'm gonna try to get you in class earlier. They finna graduate, so I'm gonna do it. I'm gonna get you that very next one coming up. Very next one coming up, jump in it, do your classes, you'll be finished with that. And like they said, Steve, you can finish that GED once you have found it, you have to get out there and sign.
I found out that we should be taking tests on the last subject like this month. So if I could pass it next month, then I'm okay.
Well, I'll be giving one time on. All right, good luck to you. Congratulations.
Thank you.
All right. Good morning. Mr. Saylor, would you introduce yourself? Tell us your name and DOC number.
You.
There you go. Try again.
John Taylor, 397-897.
All right, Mr. Saylor. Let me acknowledge the folks who joined us by Zoom in support. We have your sister Mary Shaw, your brother Eddie Saylor, and sister-in-law Tennille Saylor. Here in opposition from the DA's office in Jefferson Parish, we have Mr. Randall Meyer, and at the appropriate time, we're going to ask for all of their remarks. First, I'm going to just read some identifying information into the record, and then we'll ask for your statement next. Mr. Saylor, you're classified as a second felony offender. You're currently serving a 49-year sentence as a habitual offender, principal to armed robberies, 49 years and 6 months. Your parole eligibility date was in 2021, and your good time date is December 9th, 2048. Is that information correct?
Yes, ma'am.
And this is a rehearing for you. So you've been through this process before. It's a little different now. We want your statement first. We want to hear from you first. Tell us, how'd you get involved in all the criminal activity? And, you know, what's different about you now? Why do you think we ought to parole you?
Oh, you know, back then I was young. I was a coward. The act I did, I didn't have no sense of direction at all. But right now, you know, I'm a changed man. All that was like 25 years ago. Right now, I'm a changed man. I got my GED. I put myself in more programs like Boys to Men, things that would change. I became a mentor. Everything. I'm a changed man. I'm nothing like I used to be 25 years ago. I'm a grandfather now. I got a granddaughter. She was born February 9th.
Of this year?
Yes, ma'am.
Well, congratulations. All right, we'll ask you, dig a little deeper into that in just a minute. We'd like to hear, Warden Thompson, is there anything you can tell us about Mr. Saylor?
Saylor's doing pretty good. He started out a little rough, coming into the system, according to the dictionary record. The last 3 years, he's done well. He hadn't had a write-up. I'm concerned in regards to a program that he actually mentioned. I don't see here we actually have listed him participating to the Boys and Men program. Have you taken that?
Yeah, I'm in it right now.
Okay, well, he's currently in it right now. That would be my recommendation from the Wednesday class. I'm very proud of that Boys and Men program class. It's very effective with the offenders due to the fact of the matter, the different class that it teaches on. So that would be my recommendation that he complete that for sure.
Okay, good. Thank you, sir. We'll hear from those who want to speak on your behalf now, Mr. Saylor. So first, we'd like to hear from your sister, Mary.
Good morning, honorable members of the parole board. Again, I'm Mary Shaw, and I'm the eldest sibling in our family, the only girl among 4 brothers. I'm here today on behalf of my brother, John, and I come with deep gratitude, hope, and love. What I want you to know is John has always been a part of our family's heartbeat. We're a pretty tight group of kids. I still like to call us kids, but we're getting kind of old. Even through the years apart, we still celebrate his birthday. We tell stories about him around the table when we're together and keep his name in close prayer. Today, I'm proud to share that he is not the same man who entered those doors 25 years ago. He's grown, he's matured, he's evolved in ways that deeply move our entire family and our extended family. Just last year, John earned his high school diploma, as he shared. Here, I actually have a picture of his graduation here in my office on my desk. That moment lit a fire in him, and it was a moment of pride that I honestly hadn't seen in him before. It reminded him that he could achieve something meaningful, that he was worthy of success, and he hasn't stopped there, as you just heard him speak about. He's had dreams of becoming a chef. He probably still thinks he can cook better than me, but he probably can't. I'll take you on in that, John. And a barber. He has some other, business ideas as well, and we're here to support him in that. He's taken responsibility for his past, and he's committed to building a future full of purpose, and we're going to support him in that. He wants to give back, especially to young people. We've talked about that, who have walked down or are walking down similar paths like the one he once traveled. And I believe with all my heart that he will. in the work that I do as an educator, and there are several of us in our family that are educators. I've been in K-12 education for the last 27 years, and my brother Eddie is a teacher. He's currently in his classroom. But we work with students who remind us a lot of our brothers, of our brother, and students who have faced trauma, poverty, and systemic barriers. Many of those students need a voice like John's, and his story has the power to change their lives. And I, as well as my brother Eddie and my brother Thomas, we have the platforms to help him do that. So we're ready as a family. We've lined up jobs, financial support from our family, mental health services, vocational training, ongoing education. We're prepared to walk with him every step of the way. He's a father, a grandfather. He's our brother. He's a son, and now a man of humility, strength, and purpose. And we ask that you would consider his release, not just as a second chance, but as a chance for him to give back everything he's gained there with you. So thank you for considering his future, and I look forward to the day I can welcome my brother John home. Thank you.
All right, thank you. And we'd like to hear from Mr. Eddie.
All right, can you hear me?
Yes, sir.
All right, good morning. Good morning, members of the board. My name is Eddie Saylor. I am one of John's brothers. I'm his older, right before him. I have known John all his entire life. And I want to sincerely thank you for allowing me this opportunity to speak, to share my thoughts regarding my brother. First and foremost, I want to acknowledge the seriousness of the offense that led to John's incarceration. When I first heard about this, I was in the military serving, and I was so upset with John because we were not raised like this at all. So I was really upset to the point where I did not want to talk to him. But as I visited John and talked with him along with my wife, John or myself take the reason why he's incarcerated lightly. And I believe initially, like the gentleman shared at Allen Correctional Facility, John had a difficult time. He had a difficult time adjusting, a difficult time accepting responsibility, which kind of got me upset. But now, after talking to John and seeing the progress he's made and taking the advice of his family members, John has taken full responsibility for his actions and has expressed deep remorse for the pain that he caused to his family members, to the victims, to himself. So I know that he has taken deep remorse and understands the gravity of the past decisions, and he has shown commitment to making things right. During the time of his custody, I've seen John make some steps. I believe initially he has some difficulty with depression and things of that nature, and he did not avail himself to the opportunities that you guys have there for his improvement and advancement and his integration back into society. But John, as he adjusted, as he realized that this is serious, and as he started having more family members, grandchildren, and things of that nature, he has changed. I realize that he does realize that if he doesn't step out and take opportunity and take responsibility for his actions, he's not going anywhere. And I realize that he does want to be reintegrated back into society and to rebuild a better version of himself. So if John is granted parole, he has a detailed and stable plan, as my sister mentioned, a really detailed and stable plan to where he's going to live, what he's going to drive, what jobs that he's going to avail himself to, where he's going to go on a daily basis. As a military man, I personally will walk John back to the correction facility if he does not avail himself to every single opportunity that we have lined up for him. So I'm committed, I'm personally committed to support my brother in this transition, and we are, as his family members, as the sailors, we are personally going to hold John accountable in every step of the way. I truly believe that John is ready for this second chance, which will be a blessing. I believe that he has grown and matured and more than I've seen him in the most recent years. I've seen that he's taken leaps and bounds. Yes, he still has some things he got to take care of. Yes, he will take care of those things. So I just want to thank you for this opportunity to speak, and thank you for your consideration in this matter.
Thank you, sir. And then we have Tennille Saylor.
Good morning, and thank you for allowing me to speak today. My name is Tennille Saylor, and I am the sister-in-law of John Saylor. I've known him for many years during his incarceration. I come here not to excuse his past, but to speak of the man he has become over these 25 years. In the time, I've seen growth in his character. He has taken accountability for his action and has shown deep remorse. He's made use of the time to reflect, mature, and to better himself, not just for his own sake, but for those he hopes to reconnect with on the outside. He's completed his GED program, sought personal growth, and remained focused on positive change. What stands out most is his consistent effort to be a better person. He's taken responsibility for his life and shown humility and determination. That takes strength, and I believe he's ready to re-enter society as a changed man. Our family stands ready to support him emotionally, practically, and spiritually. We will walk beside him every step of the way. I believe in him, and I respectfully ask that you give him the opportunity to show you and the community the man he is today. I thank you for this hearing, and I thank you for your time, and we hope to have John with us. Thank you.
Thank you. Thank you all. Mr. Meyer, we'd like to hear from the DA's office, please.
Good morning, Randall Meyer, Assistant DA in Jefferson Parish. So I've spoken with Mr. Trinacosta, who's an attorney who I'm not sure if he's actually represented him in post-conviction relief, but he's trying to help Mr. Saylor out. And he sent me some information. One thing that he did give me was a November of 22 statement from the victim saying he was not opposed. However, when DOC Victim Assistance Group talked to him in 2025, and I spoke with him 2 days ago, he told both of us that he was opposed. And the statement he said about being opposed was because of his disciplinary record. He wasn't sure that if he'd be able to, how he would do on parole because of his disciplinary record. And the disciplinary record still concerns me. He's had 66 roughly disciplinary reports. The last one was in 22, a couple of months after his last hearing. And he's had a few theft disciplinary reports. For some reason, one in 2020 doesn't show up on the list of disciplinary reports, but there is a letter or a note in the record stating that there was a theft offense in 2020 to which he was ordered restitution of $17.28. Because of that and the victim opposition, we're opposed to his requests.
Thanks, sir. All right, Mr. Saylor. So let's talk a little bit about, let's dig a little deeper into what is it that you actually did to get in jail this time? What was your crime?
It's armed robbery.
Well, I mean, I know that. What did you do?
I rode around and looked for a victim. You see the victim and I robbed him. You rode in the car.
And you had a gun?
No, I didn't have a gun. The dude I was with, he had a gun. But I was with him though. That still don't determine that I'm still guilty for the crime. I still don't. But I didn't have a gun. We just rode around, just ride the dude, whoever seen. That's it.
There's some indication in the record where you had the gun.
I knew it. The warden told me yesterday, I don't think got the name mixed up. I don't know how that happened, but they got the name mixed up. I wasn't the one with the gun though at all. But that still doesn't mean that I'm still guilty of it because for the crime, but I don't know how my name got mixed up, but I wasn't the one with the gun though. But I still don't determine the fact. I'm still guilty of the charge. I was young.
So how did you get involved in that kind of activity? Have you given that some thought?
Yeah, I had thought about my girlfriend. That was my girlfriend's brother I was with. He came to the house, picked me up, and asked me for a ride. He said, "You want to go ride? Take a ride." And I'm like, "Yeah, cool." So I got in the car with him, rode, and he wanted to go rob something. So I was with it, and we see whoever we seen, and we robbed him, and that was it. But I was young, I was childish, I was a coward. Right now, I'm not a coward anymore. I learned my lesson. I never do nothing like that ever again. 25 years ago, it was stupid. It was stupid of me to do something like that. Because I hurted me, I hurted the victim, I hurted my family, I hurted my son, I hurted everybody in my life. And I don't want, right now, all that, the old me is gone. And you gonna heard from him, all the stuff I done competed, all that is out of me. The old John is dead. This is a new person. I'm a new human being. I'm born again.
So what took you so long once you got to jail to figure all that out? Because as we said, and Mr. Myers pointed it out, you got 66 write-ups. You've had 8 in the past 10 years, but the last was in 2022. So it took you a while to, kind of figure it out. Why did it take you so long, and what clicked finally?
What clicked was when my mom passed. And that clicked on me, a whole lot. When she passed, I just did a whole 360. I don't want to get my life right. I want to see my kids again. And I just turned my life around. So that really what clicked when my mom passed.
So, what do you think about the plan your family's worked out? Pretty detailed plan for your, that they've all laid out for you.
Well, I got a great support team, and I'm thankful for that. God led me for a great family, and I'm thankful for that, for real. They got a good plan for me, and I got a good plan for me.
So how long have you been in the Boys to Men program?
I've been 6 months. I'll be finished in two weeks. I'll be finished that program.
So you're at the end of it.
Yeah, I'm at the end of it.
Where are you going to live? Whenever if you were successful, where would you live?
Right now, I got to live with my brother. Live with my brother, Thomas.
Is that in Jefferson Parish? Where is that?
No, that's in Houston.
Okay.
Texas.
Well, that sounds like a pretty good plan.
Well, he got.
Where's he at today?
I think he's at work. He got a lot of businesses, so he be real busy. He be at work. He got a lot of business he own. He own a CDL company. He got a security company. He got 2 daycare centers. He real business. He can start give me a job, so everything be good. Like my family, they got a whole setup plan for me already. I'm gonna get my own house. They're gonna give me all that, buy me a car and everything. So I should be straight. They got a good plan set up for me. I'm thankful for that, and I'm blessed for that.
You're very lucky in that regard. We don't see that often. You're very, very blessed there.
I'm blessed.
All right, I don't have any other questions of you, Mr. Saylor. I'm going to turn it over to my colleagues. Mr. Folly, got any questions?
I have a question for Mr. Myers first. You could answer. In the police report, they say he's the guy with the gun, correct?
I was gonna say something about that. Mr. Saylor, from what I've seen, the research I did, he was the driver, did not have the gun. The other defendant, who pled guilty and was given a 15-year sentence was the guy who had the gun, who got out of the car and put the gun in the juvenile's face. From everything I've seen, Mr. Saylor did not have a gun.
Okay, thank you. So you took part in this robbery for what reason? What were you trying to get money for?
I mean, it was food. I wasn't even trying to get money. I guess I just want to be down, I guess. I just did just be doing. I didn't have no sense of direction at all. I was young. I had a child state of mind. I'm not a child anymore. The class that I'm taking, all the courses I've taken, it transformed me. It really transformed me. Like the warden said, thing of a chain class and the boy to man class is the same that we said that it's like when I was a child, I spoke as a child, I understood as a child, and I thought as a child. But when I became a man, I put away childish things. And all the things I did, I put all that away. I'm not a child anymore. I'm a grown man now. I'm 49 years old. I came in jail. I was young. Like I said, I'm a grandfather now. I got a granddaughter. So all the stuff I did, it's over with. I'm a man now.
That's all the questions I have.
That answered my question.
All right, I don't see any other questions, Mr. Saylor. And how many parole hearings have you had?
This is my second one.
This is just your second?
Yeah, my first one, he told me to get my GED.
And you did?
Yes, ma'am. I'm proud of myself, too.
Yeah, you should be. I am too.
Thank you.
So is your family, I'm sure. So listen, Mr. Saylor, your record is concerning, but I am most impressed with the things that you and your family has said today. I particularly that your plan would be to go to Texas and not back to Jefferson Parish. I had some concerns about that. My vote today is going to be to grant your parole after you finish that Boys to Men program, which is soon. And then with the stipulation that you do the interstate compact to Texas with your brother. And follow the plan laid out by your family.
Yes, ma'am.
I'm just one vote. Mr. Byron?
I'm going to concur with Mr. Renatza, and I'm going to also add the condition that prior to release, you complete the victim awareness program and the victim accountability program. Also, upon release, that you're not associated with anyone who possesses a firearm. You can't associate. Your brother's going to have to give up any firearms if you live in his house. There's going to be no firearms in the house, and you can't have friends who have firearms. There's no excuse that I didn't have the gun, he had the gun. You can't be in the car, you can't be in the same room, you can't be in the same house. And also that you cannot return to Jefferson Parish.
All right, Mr. Stapleton? I concur with Ms. Renatza and Mr. Barra.
All right. You got a favorable decision. Aren't you excited?
Yes, I am. Thank you.
All right. Good luck to you.
Thank you.
All right, Warden, that concludes our business. It's 9:51. We're going to sign off. Thank you so much.
Thank you.
Thank you.
Congratulations.
Wow. Yes.
your DOC number.
My name is Quentin Beach, good morning.
Good. Would you introduce yourself? Tell us your name and your DOC number.
My name is Quentin Beach, DOC number 713143.
All right, that's what I have. Thank you, sir. And you are represented by counsel this morning. Good morning, counsel. Would you introduce yourself for the record?
Yes, Your Honor. Good morning. I'm Kelly Cormina on behalf of Mr. Beecham with Southern University Law Center's Law Clinic.
Okay, and thank you for being here with Mr. Beecham this morning. Mr. Beecham, you're here for a revocation decision. You understand that? Mr. Beecham, did they freeze up? All right, let's see if we can get them back.
You crossed.
I think they may have signed out and going to try to sign back in. All right, there you are. You had froze up for a second. Mr. Beecham, I was asking you to be sure you understand you're here for a revocation decision today.
Yes, ma'am.
Okay. So first, I'm going to read the allegations against you. I'm going to ask you to enter a plea of guilty or not guilty. And then we're going to ask your attorney for her remarks or comments that she may have. All right, you ready?
Yes, ma'am.
Okay. You're accused of violating the conditions of your parole. And first is the first instance of condition number 4, and that reads, you failed to refrain from criminal conduct as evident by your arrest March 16, 2024 by the Baton Rouge Police Department and were charged with domestic abuse, battery, simple criminal damage to property. On March 26, 25, you pled guilty to simple criminal damage to property, which correlates to the arrest on March 16, 2024. How do you plead to violating condition number 4?
Guilty.
Okay. We have another one that is also condition number 4. It says, additionally, you further engaged in criminal activity on or about November 6, 2023, as evident by your arrest by the Baton Rouge Police Department and were issued a misdemeanor arrest summons for theft. How do you plead to that violation of condition number 4?
Not guilty.
Okay.
Yeah, I wasn't billed for that.
I'm going to ask you about it in a minute. After we hear from your lawyer, we can ask you about what happened.
Yes, ma'am. Sorry.
That's okay. Lastly is another number 4. You were also engaged in criminal activity on or about the date of February 26, 2024. As evident by your arrest by Baton Rouge Police Department, you were issued a misdemeanor summons for simple criminal damage to property. How do you plead to that violation?
Not guilty on that one too, yeah. Yes, ma'am.
Okay. All right. And last was about your fees. It says you had violated number 10, condition number 10, because you failed to pay your parole fees. You were currently $189 in arrears. How do you plead?
Not guilty. I explained it.
Okay. So, Ms. Carmina, would you like to speak now, or you want me to take his statements first?
It's whatever y'all would like. I would like to state his parole officer, Mr. Gerard, said that he's waiting in the waiting room and no one's let him in. I don't know if y'all want to let him in.
Yes, thank you. I appreciate it. Can y'all let Mr. Gerard in? He's on the Zoom. Oh, yeah. I'm sorry. Yeah, I was thinking about that. We're gonna get him.
He just sent me a text message asking if I could let y'all know.
Yeah, thank you. Do you see? Oh, there it is. So is that, Mr. Gerard? It says Carl.
Yeah, I don't think that's him. Well, I don't think that's him. I don't know.
It should be Mr. Gerard. Gerard. G-I-R-R. We don't have him. Can you text him? We don't see him?
She got texting ID.
Ms. Carmina, can you text him back and ask him what's his device name? Because we don't see his name. We have somebody named Sutherland, I believe, that's in the
He said his ID is POO345935.
In the wrong waiting room. She needs to text him.
Okay. So we're gonna give you, he's apparently in the wrong meeting room. We're gonna, if you could text him the correct meeting number, the same one you used to dial in.
Okay. Give me 2 seconds.
Yeah. Put you on hold.
Kind of told me I was an adult and I needed to just take care of my yard. So when I went up to the city office, spoke with a nice lady at the front, and then showed her the pictures of where all of the like weeds are coming from my neighbor's yard over into mine. So whenever I would cut my grass, I would take care of it, and I would, weed whip or cut down whatever is encroaching on my side. But it was kind of always a Band-Aid, never like a permanent fix.
Okay. And then did she tell you, how did you get the impression the ticket was dismissed?
That when I spoke with her up at the front after showing her the picture, she said, okay, we're going to send somebody out. You should be good. And I kind of took that as I'm, I guess, off the hook or that it was going to be okay. Because I figured that they were just going to issue him the ticket at the time. And then I received the notice to show cause a couple months later. So then I was back on the same.
Okay. Ms. Vitorino, did you get a chance to see any of these photographs or have any of these discussions with the ordinance officers?
Your Honor, the ordinance officer indicated to me, she sent me a couple of pictures. They're a little grainy because they're a picture of her computer screen showing some of the overgrowth. And she indicated that she had given Mr. Gaddy a notice a month, like 30 days before before she issued the ticket of the violation. And so she didn't want to, because I had indicated to her the ROA indicated that he thought the ticket was going to be dismissed, and she said that she did not want to dismiss the ticket.
Okay. Well, I'm taking the ticket out of default. He's appeared today. He had a misunderstanding, and we can set a hearing, sir, with the ordinance officer present and photographs if that's how you'd like to proceed.
Yes, Your Honor. Me and my neighbor have worked out now. Like he went in and like cut it all down from his side, and then we're gonna get slots. What wasn't clear to me when this happened is also when I called, they said, do whatever you did a couple weeks ago because they issued you a warning and then pulled it. I never received that warning either.
All right, well, we'll set it for a hearing and they'll have their paperwork here. You'll get notice of that in the mail. Okay? That'll be in person.
Yes, Your Honor.
All right, we're all set.
Thank you.
Okay, Garcia. This is 2504730M, this, City of Taylor versus Gadiel, Garcia. Good morning. Madam Interpreter, do you solemnly swear or affirm to accurately and completely translate from English to Spanish and Spanish to English?
Yes, Your Honor. Angelica Hernandez interpreting in Spanish for Gadiel Josue Garcia Garcia.
Good morning, Your Honor. Jeffrey Fanto on behalf of Mr. Garcia. Waive formal reading and stand mute.
Se denuncia la lectura de cargos formal y se guarda silencio.
Okay, Mr. Garcia, did you go over your constitutional rights with your attorney?
Señor García, ¿le explicaron sus derechos constitucionales con su abogado? Yes.
Did you understand your rights?
¿Usted entendió sus derechos?
Sí.
Yes.
And did you give Mr. Fanto permission to put your name on this document?
¿Y usted le dio permiso al señor Fanto de poner su nombre en este documento?
Sí.
Yes.
Okay, I've entered a plea of not guilty on your client's behalf.
De parte de su cliente ha puesto una petición de que no es culpable.
Asking the matter be set for settlement conference with Macy's to provide video or otherwise appear.
Vamos a fijar el asunto para una conferencia de resolución para que Macy's proporcione fotos o comparezca.
Okay, we'll set it for a settlement conference, and sir, you'll receive notice of your new date in the mail.
Bien, vamos a fijarlo para una conferencia de resolución y señor, usted va a recibir notificación por correo.
He does have a new address, Judge.
I just marked the file to note that he had a new address.
Marqué su carpeta que tiene un nuevo domicilio.
And sir, you have $1,000 personal bond. That means you don't have to post any money.
Señor, usted tiene una fianza personal de $1,000, pero eso significa que no tiene que depositar dinero usted.
You're to appear in court as directed.
Tiene que comparecer al tribunal como lo dirigen.
You're not to leave the state without permission of the court.
No puede salirse del estado sin tener permiso del tribunal.
You're not to commit any new crimes while released.
Mientras de estar liberado, no puede cometer nuevos delitos.
You're to immediately notify the court of change of address or phone number.
Inmediatamente notificarle al tribunal si hay cambio de su domicilio o de su teléfono.
And you're not to enter Macy's while this case is pending.
Mientras de que este caso esté pendiente, no puede entrar a la tienda de Macy's. That's fine.
Okay, we're all set. We'll send you your next court date in the mail.
Bien, estamos listos. Le mandaremos o le enviaremos su nueva fecha por correo.
Okay.
Okay.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank you, Ms. Hernandez.
You're welcome.
La nueva fecha me la van a mandar por correo postal o por correo electrónico.
Oh, and will I be receiving that new notice by electronic mail or by the regular mail?
Regular mail.
Va a recibirlo por el correo regular.
Correo electrónico, entonces.
No, email
Postal.
them.
Okay.
Email them. And I said, no, no, por correo.
Okay, está bien.
Okay, that's fine.
Thank you.
Thank you.
Are we ready on Christina
Adios.
Kurtz? Adios.
Yes.
Ms. Kurtz, she was excused.
Yes, Your Honor. Jeffrey Fanto on behalf of Ms. Kurtz. The matter's been resolved and that's to be dismissed.
All right, 251176, the People versus Christina Kurtz is dismissed.
Thank you, Judge.
Thank you. And Mr. Garcia, you can hang up.
34th.
What time is Kurt's schedule? Give me just a moment. Are we ready on Beth Melton? 145 was Kurt's. Thank 145. Thank you. Melton, give me just a moment. I'm waiting for your attorney, okay? Okay, thank you. Do I have Sana? Yes. Boomhelm? Ma'am, can you come on up? All right. Hi, good morning. This is 25173850, the City of Taylor versus Sana Boomhelm. Yes, sorry. Ma'am, I have a note in the file. Did you have a chance to meet with the prosecutor? I have. And it says that we're just asking to adjourn it for a few weeks because you have your signing scheduled. Correct. Yeah. So what we'll do is we'll send you the new date in the mail. I know the prosecutor wrote 2 weeks. It might be 3 to 4 weeks. Okay. So we'll send you notice of the new court date in the mail. Okay? All right. You're all set. Thank you. Williams, give me just a second, okay?
No problem, Your Honor.
All right, this is 25175-104 and 25175-105. The City of Taylor versus BCSK Rental Properties LLC. Council appearances.
Good morning, Your Honor. Michael Williams appearing on behalf of BCSK Rental Properties LLC.
All right, I have in front of me a request from the prosecutor to adjourn this 60 days so that the inspection can happen. Is that correct?
That's correct, Your Honor.
All right, there won't be further adjournments given the length of this. But it'll be adjourned. Okay, we'll adjourn it 60 days. I'll send you, well, I won't personally. The court will send you notice in the mail.
Okay, thank you very much, Your Honor.
All right, thanks.
Have a good day.
You too. All right, this is 2506340T, the People versus James Smith.
Morning, Your Honor. Jeffrey Phantom on behalf of Mr. Smith. Mr. Smith is going to plead guilty to admitted charge of allowing a licensed person to operate and responsible for the admitted charge of double parking. We'd request a $50 per month payment plan.
All right, Mr. Smith, does that all sound accurate to you?
It do, Your Honor. Yes, it does, Your Honor.
All right, and you understand allowing an unlicensed driver to drive is still a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Do you understand that?
Yes, Your Honor.
Okay, and did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, Your Honor.
Did you understand your rights?
Yes, Your Honor.
And did you give Mr. Fanto, your attorney, permission to sign your name on this document?
Yes, Your Honor.
Sir, you understand that if you enter a plea of guilty, you'll be waiving the trial rights listed on this form. There will be no trial of any kind.
Yes, Your Honor.
Okay, and sir, you understand that if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
Yes, Your Honor.
All right, and if you are not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation. Do you understand that?
Yes, Your Honor.
Knowing all of that, sir, how do you plead to the amended charge of allowing an unlicensed driver to drive?
I plead guilty, Your Honor.
Has anyone forced you to get you to plead?
No, Your Honor.
Has anyone promised you anything other than the plea agreement to get you to plead?
No, Your Honor.
Are you pleading guilty of your own free will?
Yes, Your Honor, I did it. Yes, ma'am.
All right, sir, were you operating a motor vehicle in the city of Taylor on February 25th of 2025?
Yes, Your Honor.
And while you were operating that motor vehicle, were you unlicensed? Was your license suspended, revoked, denied, or were you otherwise ineligible to have a license at that time?
It was suspended, Your Honor. Ma'am.
All right, and did you allow yourself to operate that motor vehicle?
Yes, ma'am, I did it, ma'am.
Satisfied with the plea, Mr. Fanto?
I am, Judge.
Okay, I'm going to accept the plea as knowing and voluntarily given. Sir, you have a $100 fine, $100 court cost, prime victim's rights fee is $75, and a state assessment of $50. Those last two are mandated by the state of Michigan, and that brings your total to $325. You also have this civil infraction. It was a very expensive ticket, and that's being reduced, and it had points on it. It's being reduced down to a double parking. That's a 0-point ticket with a fine of $165. Would you like to take advantage of that offer?
I sure will, Your Honor.
To double parking, how do you plead? Responsible or not responsible?
I'm responsible, Your Honor.
Okay, and that would have been on the same date as the other offense, correct?
Yes, Your Honor.
Okay, I'm going to accept the plea as knowing and voluntarily given. That is a fine of $165. It brings your total to $490. And Mr. Smith, I'm going to give you a payment plan of $50 a month, okay?
Thank you so much, Your Honor. I really appreciate that, Your Honor.
Listen, Mr. Smith, if you're going to be late on a payment or you don't have the full amount, call the court, okay? So you don't end up show cause or getting a bench warrant or assessing more, late fees on it.
I sure will, Your Honor. I took your advice, Your Honor. Have not been driving lately at all, Your Honor.
Good, make good choices. And
Yes,
you're all set, Mr. Smith. Have a good day.
Have a good day, Your Honor. I appreciate you. Yes, ma'am.
Thank you, Judge.
Yeah.
Have a good day, sir. I appreciate you.
Yes, sir.
232746, 232745, 232747, and 243177.
Good morning, Your Honor. James Kazicki on behalf of Miss Milton. Your Honor, Miss Milton's going to enter a plea to possession of paraphernalia, the incident that happened August 23rd of 23. The prosecutor has agreed to dismiss the remaining cases, basically because she's on felony probation now with Judge Ramsey, Your Honor.
All right,
She's
Ms.
been
Milton, are you?
incarcerated since June 2nd. She's been incarcerated on this case.
Okay. Ms. Milton, are you in a treatment court program under Judge Ramsey?
I guess you could, I have to drug test 3 times a week. I have to go to intensive outpatient. I have to go to 3 NA meetings a week.
How are you doing?
Great. First time ever.
Better?
First time ever.
Good. You look better.
Thank you.
I'm happy for you. I hope you continue on this path. So
I got a whole new life.
And Judge Ramsey is a very good judge. I know her well.
Yes,
she's very passionate. So you ended up in a good courtroom down there. So you understand, ma'am, this plea. So all these cases will be dismissed. And then on the paraphernalia case, you'll take a plea on that. And you've been in custody, and since you're under felony probation in at least what sounds like a treatment court program, I'm going to just give you credit for time served on this case since you're already under supervision from a higher jurisdiction. Okay?
Thank you, ma'am.
All right. So possession of paraphernalia is a misdemeanor. It's punishable by up to 90 days and a fine of up to $500. Do you understand that?
Yes, ma'am.
And Ms. Milton, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, Your Honor.
Did you understand your rights?
Yes, Your Honor.
And did you give Mr. Kazicki permission to sign your name on that form?
Yes, Your Honor.
Ms. Milton, you understand that if you enter a plea of guilty, you'll be waiving the trial rights listed on this form. There will be no trial of any kind.
Yes, Your Honor.
Okay. And you understand that if you are currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
Yes, Your Honor.
Okay. And I assume your PO is aware of all these outstanding cases.
Yes, Your Honor.
Okay. And you understand that if you're not a citizen of the United States and you enter a plea of guilty, it could result in immigration consequences up to deportation?
Yes, Your Honor.
Knowing all of that, how do you plead to the charge of possession of drug paraphernalia?
Guilty.
Has anyone forced you to get you to plea?
No, Your Honor.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, Your Honor.
Are you pleading guilty of your own free will?
Yes, Your Honor.
Ms. Melton, were you in the city of Taylor on August 23rd of 2023 in the area of the Walmart?
Yes, Your Honor.
And while you were there, did you have something in your possession that would make you guilty of this charge?
Yes, Your Honor.
What did you have, Ms. Melton?
Digital scale and some straws.
Okay, what were those straws used for?
Drugs.
Okay. Mr. Kazicki, are you satisfied with the factual basis?
Yes, Your Honor.
Okay, I'm going to accept the plea as knowing and voluntarily given. And ma'am, Mr. Kazicki, did you say she'd been, I'm gonna give her 30 days credit 30. Has she been in 30?
Yeah.
Sounds good, Your Honor.
All right, you got 30 days jail, credit 30. And all fines and costs are waived. You've got bigger fish to fry downtown.
Thank you, Your Honor.
Ms. Mountain, take care of yourself. Keep going. You look better than I've seen you quite a bit. I've never seen you look as alive, and I'm just really happy for you, and I'm hopeful that you continue on your journey.
Thank you.
Good luck, ma'am.
Have a great day.
Thank you. Do I have Cheyenne Kunzelman? Good morning. Morning. This is 2517-4953, the City of Taylor versus Cheyenne Kunzelman. Good morning, ma'am. Can you tell me your first and last name?
Cheyenne Kunzelman.
All right. Ma'am, I have in front of me this litter, trash, and rubbish citation, and there's a note from the prosecutor that indicates if you pled responsible, should reduce the fine to $80. Do you want to take advantage of that?
Yes.
Okay, to the allegation on 4/4/25 at your property located at 16951 Ziegler in the City of Taylor, you had litter, trash, and rubbish in violation of city ordinance. How do you plead, responsible or not responsible?
Responsible.
Okay, I'll accept that plea. It's a fine of $80. When will you be making payment?
That's what I have to talk about. I just made a payment, I had a, is there any?
You just tell me when you can pay it. It's okay. I'm not gonna yell at you. You need 30 days?
30 days. I'll say 30 days.
30 days to pay. Okay? And if something comes up and you don't have the full 80, call the court. Okay?
Okay.
All right, you're all set, man.
Thank you so much.
Yeah. We'll check on it. Have a seat out there. I'm gonna let you go. Thank you. So he just adjourned it, so I just. So we're just gonna adjourn.
Right here.
No file, I don't have a file on it. It was supposed to be at 10 o'clock. I don't know what file, because there is no file.
Wonder if it's on the other side.
Check all the rest of them, I don't think it's in there. Here. No, it's going. That isn't through all these.
What's that? Mario, if you want to talk, can you let me know, because I haven't seen this.
Yes, absolutely. You're welcome. Get out of the way. Yeah, it wasn't in the file, that's why I marked it when I went to the next segment. It was supposed to be at 10 o'clock. Guess adjourn. No, I'm sorry, I have to call Dana. She's sitting there. I don't know why. Tell her I'm calling her. They're just transfer me to her. How about that? Thank you. Thanks. Hey, I don't have a Galloway file. It's scheduled at 10. Scott's looking through the afternoon bucket. I went through all the morning bucket and they showed up in person. Yeah, you want the numbers? 2517. You did? Yes, that's it. Okay. All right, so I'll look in there, you look down there and let us know either way. If you find it, I'll let you know if I find it, okay? All right, bye. Eno said that he got an adjournment request. She's gonna look down there to see if it ever came back down on the Twitter office. No, that was Patel. That's the guy that was standing out in the lobby and I had told him she adjourned. I gave it to Angela. She's gonna give it back to us. So I'm gonna go look for Galloway, maintain this. And, okay, and you understand, sir, that if you enter a plea of guilty, you'll be waiving those trial rights. There will be no trial of any kind.
Yes.
Okay, I'm just gonna publish it, Your Honor. State Exhibit 1 is a 5-page document, if that's fair. And can you tell us, with respect to page 1, what's the significance of page 1?
So it just shows the history on her phone that has been used in Messenger, and one of those is to Mr. Salyunek.
And the arrow is pointed up or down to the...
It's up, so that means that's an outgoing call to Mr. Salyunek from the victim.
Okay. Page 2 then, what's the significance? What's on page 2?
So the reason, so again, this is because it shows Saturday, I didn't want there to be any discrepancy about what Saturday we're talking about. So the metadata shows it's June 2nd is when they took the photo, so it would be the Saturday before June 2nd.
Okay, which is when our victim, Ms. Phillips, attempted to contact the defendant.
Correct.
Okay. Page 3.
So this is, that, the other stuff was, the previous said was a message, I'm sorry, they were calls. This is actually messages, Facebook messages, and again, it's a picture of her entire communications with various people, one of them being Mr. Salyunek.
And that would be where it says, "I love you, sweet," at least part of it.
That's correct.
At 6:01 p.m. Then we have page 4, and what's that?
So once you click on his name, it would open up the entire communication thread with Mr. Salyunek. That is the specific message that they were talking about, where he was going to send Kim to get his belongings from her in the nursing home.
All right. And then below that it says, "I love you, sweetheart, so much."
That's correct.
Okay, and that supposedly was sent on 6:01 p.m.
Correct.
But we don't have a date on that.
Of a day, yeah.
Okay, so let me show you the last page of that. Do we have the metadata then on that?
So the metadata shows that they took this image on June 2nd. If you go back 2 slides.
Back 1 or
2, that one right there. Actually, that one does not even show the day. So it just shows that they took the picture on June 2nd.
All right, but because the picture was does it have Saturday on it like the
It
call
doesn't,
does?
so it would be the day that they took the picture. So that would have taken place on June 2nd.
This conversation about Kim and all that?
Correct.
Okay. All right, so then after you obtained that, we filed the motion. On June 9th, did you have, so this would have been just this past Monday, did you have more contact with Shannon Phillips' daughter-in-law, Olivia Lawrence?
I did. So I reached out to Olivia because on the first one where we're talking about an audio message, there's no information about whether or not there was any call duration, about whether there was any connection.
So on page 1 of Exhibit 1?
Correct. So I wanted them, I asked them to go in and actually hit the I button so that you can see if there's any call duration to see if they actually spoke or if she just reached out to him.
All right, and I'm going to show you State's Exhibit 2. Is this the type of call duration that you were hoping to get from that particular call?
It is. It goes into more detail about how long, who called whom, and if it was successful.
Okay. See that? Yeah. 3 pages. Okay. So, State's Exhibit 2, when you're talking about call data, that's from calls on May, at least on page 1, it's a 3-page document. That's from calls on May 28th of this year.
Yeah, so this is an example of communication with Mr. Salyunek. It shows an outgoing, an incoming, and then one that was not completed, and it includes the call duration of each communication.
All right, so this is, when it says messenger audio, Ray Salyunek at the top, are we talking about this is off of Mr. Salyunek's phone, or is this off Ms. Phillips' phone?
This is off of Ms. Phillips' phone, and the name is there because that's who she's communicating with from her friend options.
So there would have been an outgoing call from Ms. Phillips to the defendant on May 28th at 4:35 for 4 minutes, and then an incoming call at 4:16 for 17 minutes?
Correct.
Okay. So that was May 28th. And then we also have something from June 3rd, is that on page 2?
That's correct.
And again, that's an incoming call. Would that be from the defendant to our victim?
That's correct.
And that lasted 17 minutes?
That's correct.
And then lastly, on page 3, we have from June 6th, which also we have Facebook messages from June 6th as well. Is that?
That's correct.
All right, and on that day, we have just missed calls. Does that mean missed calls by Ms. Phillips to the defendant, or how does that work?
This image isn't actually going to show you who facilitated the calls. You would have to go back and look at that call thread, like the communication thread, to see which end it's coming from.
Okay, so if we look at June 6th Facebook messages, we may have a corresponding.
That's correct.
Missed call, okay. I'm going to show you, were you informed that there were also more Facebook messages that we had not received yet?
I received those when I received these. That's correct.
Okay, and those ones you just received, I think, late on Monday?
Yeah.
All right, and that would have been from Olivia again?
From Olivia, yeah.
And again, purporting to be screenshots off of Shannon Phillips' phone involving Facebook messages between Shannon and the defendant?
Yeah.
And then we have June 6th, or June 4th, June 5th, and June 6th, is that fair?
Yes.
Okay, let's start with June 4th. State's Exhibit 3. Okay. It's a multi-page document, is that fair?
That's correct.
And those are at least purporting to be Facebook messages from June 4th between Shannon Phillips and the defendant, Mr. Salyer.
That's correct.
All right. Now, let me ask you, with respect to like State's Exhibit 1, when you pull up the messages that we first received last week, excuse me, do we have the Facebook profile on there?
Yes, so his profile picture is the one I saw on Thursday. It was of his face.
Okay, so that was what you pulled up when
On
you pulled
Thursday,
up
that's what was there,
the
correct.
Facebook profile. And then in State's Exhibit 2, we don't have a Facebook profile anymore?
It just has his initials.
And do you know, I mean, what do you have to do in order to just have initials? Do you know?
Yeah, you can deactivate your Facebook and still maintain your message app.
Okay, so if you deactivate it, you won't have a picture up there?
Correct.
All right, so we're at State's Exhibit 3. At this point, just for the record, since we're talking about that, we have a different Facebook profile on State's Exhibit 3.
That's correct.
And that is now of what?
Marvin the Martian.
Okay, but this is from June 4th, which would have been the day before you looked on his profile and saw his actual face on the profile. So is this a different?
So when you change your profile picture, your entire communication thread, like it changes everything. It will change the image that if yesterday you talked, same image will be whatever you changed it today to.
If I changed it today to like Mickey Mouse, then if I pulled this back, these same Facebook messages back up, now Mickey Mouse will be on there?
That's correct.
Okay. All right, so with respect to June 4th, it purports to be from Ray Salyanek with Marvin the Martian on it. And it goes into between, in all fairness, we have our victim responding back, telling the defendant she loves him.
Absolutely.
Okay, and then in this, we go into page 1, page 2. They're confirming that where she was, or we're going to.
Where she's moving to, yes.
And that was going to be where again?
Laurels of Milford.
Okay, and that's true?
That is true.
I mean, that's not something that's made up?
No, she's
Okay.
there.
On page 3,
They're still talking about it.
about Laurel's, okay. But again, page 4, this is coming, we have text messages from the defendant. I need this to get done, Shannon, so it's going to our victim. Don't do this to me, please. I paid your rent and your electric and have taken care of you. Please don't do this to me. If you love me, don't let this happen. And she's responding, I do love you.
That's correct.
All right. Page 5. He starts talking about he's gonna go back to jail. And then at this point, we have a missed audio call on June 4th, but we don't have the corresponding missed calls that we received.
That's
So we don't
correct.
know-
They did not send me the screen log from June 4th. I don't have that.
Page 6, though, they continue on. She's mentioning, and Ms. Phillips is mentioning Kim's name about talking to Ronnie, and do we know who Ronnie is?
Ronnie is Veronica.
And who's that to Ms. Phillips?
Daughter.
Daughter, okay. All right, and defendant's asking if she wants him to have Kim call Ronnie, and that how he's been doing it for a month. How can you do this to me? You know what the consequences will be if I don't get these things. It will decimate what is left of we'll go on to the next page. It'll decimate what is left of my life. How can you do this to me? You haven't even asked her to do it. I can't believe this. You're breaking my heart even worse because I know you haven't. Continuing on. Because I know I'm devastated right now. You're gonna let me go back to jail after everything I've done for you. And she's responding back, correct?
Yes,
She's
with
not telling-
emojis. It looks like with emojis and with messages.
She's not telling him to stop calling or contacting her?
She's not.
Okay. And then the next page, I didn't think twice when you needed your rent paid and your electric bill paid, or when you needed me to take care of you when you were getting sick, and she's appreciative of that. But then he goes back to if it's okay if I go to jail.
Correct.
All right. June 5th, then, we have more conversations.
Yes.
States Exhibit 4. Okay. And for the record, all of these exhibits so far have been a fair and accurate copy of the messages that you've received.
Correct.
Okay. So State's Exhibit 4 starts with June 5th, beginning at 9:48 in the morning, where she's contacting him, telling him she loves him.
Yes, she initiated that.
Okay, and then this is June 5th of 2025. It mentions that exactly 1 year ago, this is very minute, I was ripped away from you, thrown violently into the back of a police car, and taken to jail. When we're here, the felonious assault, strangulation, and all that case was, that happened on June 5th of 2024?
That's correct.
Okay, so it has been 1 year.
Yes.
It then goes into the fact that I was ripped away from you again 3 months ago and thrown back into the police car and taken to jail again for 40 days. Continues on. It's fortuitous that it's going to happen again, and this time I won't be getting out of jail until after the trial is over. Imagine the crushing hurt, betrayal, and heartache I am feeling right now on this 1 year anniversary. And then he continues on about going back to jail.
Correct.
You've decimated my life. If there's something, when there's something you could have done to prevent it, which continues on. And again, for the record, we have Marvin the Martian at the top with Ray Salyumik's name.
Correct.
Okay. Sorry, 6, going back to the first page. And then it goes into 6 years of being together, finding my soulmate, my Sally, only to be forsaken by you because you refused to upset your wonderful kids who have abandoned you. I was the one that was there for you when you were abandoned by them. I'm the one who helped you stay afloat after everything happened, not them. And he just continues on. Do you know how bad it sucks to know you never cared in the first place? I guess it doesn't matter now. I wonder how long they will stick around. Continues on. Well, I guess this is the last you will hear from me. It's not as if you responded to all of the love I sent you anyway. I hope you're safe and comfortable while I rot in jail again. And that's what we have from June 5th.
That's correct. And that actually lines up with a post he had made when his profile picture was different.
That's going to show you State's Exhibit 5. Is that a copy of that? Yeah, an accurate copy of that?
Yes.
And this, what's this a copy of?
So this is just a screenshot of his profile that when the profile picture was his face, this is his public page that he had posted 1 year ago at this very moment, which lines up with the messages that she was receiving on that same day.
Okay, so that picture, is that the same kind of picture you saw when you pulled it up last Thursday?
That's correct.
Okay, and Thursday of last week would have been June 5th.
That's correct.
And this is the meme that would have been sent by at least Ray Stalianek about 1 year ago at this very moment.
That's what he posted to his, to the public profile.
Public profile?
Yes.
All right. Then the last group of Facebook messages we received were from the June 6th, which would have been Friday.
Correct.
Okay, you can tell me if that's a State's Exhibit 6, is that a fair and accurate copy of those?
Yes.
All right. And last, with respect to State's Exhibit 6, now this is the date that we have that would correspond, just for the record, with State's Exhibit 2, which would be on the list of calls.
Correct.
All right. So with respect to State's Exhibit 2, while we're looking at State's Exhibit 6, we have calls at what times?
So we have a call at 1:46 p.m., 10:40 a.m., and 8:34 a.m.
Okay, so it goes bottom
Goes
to
bottom
top
up,
in
yeah.
order. Okay, so 8:34 a.m., 10:40 a.m., and 1:46 p.m.
Correct.
All right, so looking at State's Exhibit 6, which are the Facebook posts, again, with Marvin the Martian at the top with Raymond Salia. Okay. And starts at 8:33 in the morning. And starts with her, again, contacting him.
It does look like she initiated that call, although it wasn't successful. She's the one that it was an incoming call to him.
All right, and just below that, he responds, and then we have a missed call on June 6th at 8:34 a.m.
Correct.
Does that correspond to the missed call on State's Exhibit 2?
It does.
Okay. Now, on this one, can we tell who called who?
So it's on the left side, so that is her to him.
Her calling
him.
him?
Correct.
Okay. So if it was on the right side, it would be him calling her?
Yeah.
Is that how it works? Okay, thank you. All right, so we have that missed call. But then he asks, isn't that him saying, you can't even take my call?
Oh, I'm sorry. Yeah, I did that. I swapped them. My bad.
Okay, so let me go back to
Yes.
this page.
So it's next, yes. So that would be him actually then calling.
it's on
You
the
can't
left
even take
side.
my call because it's next to Marvin the Martian.
Okay. And it's under his part of the Facebook messages?
Yes.
Okay. So then he says, you can't even take my call. She's talking to somebody. He gets upset, and you put a laughing face about what I said about what happened a year ago. And she's like, sorry, it was an accident. Goes on. That will continue into the next page, starting with, so that's it. We sit at the side of the road. And she's like, together. He's like, how can you say that when you've forsaken me? Going on to the next page. When you've forsaken me, I'm going back to jail because you refuse to get me what I want. I need to stay out. We are not on the same side of the road. I'm in the middle of it, being run over. Even though I didn't even think twice about giving you what you needed. She responds back, if I could have, I got a hold of what I would have, that makes you not talk. And he's like, what? And then right down below that at 10:40, it's going to be better on the next page. At 10:40, And we have a missed call. And does that again correspond with the missed call that's on the list?
It does.
And for the record, this missed call is from whom?
It was from Mr. Salunek to the victim.
Again, because it's on the left side versus
Correct.
the right side. Okay. And then she's having someone coming from hospice right now, and he's like, that's fine, I get it, don't answer your phone, avoid the whole thing while I suffer. That's the way it's always been. If you just avoid it, it doesn't exist, and everyone else suffers while you don't have to deal with it. That's fine, I won't contact you anymore. And then we have, the next thing is at 1:34 p.m., which is the defendant asking her, Shannon, did you turn me into the prosecutor?
That's
For the record, had the motion to revoke his bond been filed by 1:46 p.m.?
It had.
Or 1:34 p.m., excuse me. And then on the last page, right below that, is a 1:46 p.m. this audio call, which, does that correspond again with State's Exhibit 2?
It does.
And again, these are all fair and accurate copies of all the voicemail or Facebook messages and items that you received. And this would have all been from Olivia?
That's correct.
Reporting to be off of Shannon Phillips' phone?
Yes.
All right, and was there anything in there that indicated that it wasn't off of Shannon Phillips' phone?
No, it looked right to me and actually lined up with some things defense gave as well.
All right, and for the record, the reason why we're pointing out Marvin the Martian is because why?
Because I had received those messages from Olivia. Later, I came into possession of the motion that the defense filed, and he said it would have shown Marvin the Martian had it been him, when that's in fact what the profile picture was changed to.
Okay. And there was also indications in the memorandum in opposition to our motion to revoke bond that she was fraudulently using his credit cards to pay for her rent and utilities.
That's correct.
And that would have been at least contradicted by what was purported to be his Facebook messages to her that he was paying for her.
That's correct.
Okay. Just a moment. All right, and this is the same Raymond Salunek that we have here.
That's correct.
You're in this all.
Cross? Yes, thank you. Good afternoon, Ms. Kennard.
Hi, how are you?
Good to see you again. Obviously not social.
Fair.
Ms. Kennard, you can put, when you have a contact, whether on Facebook and your phone, you can put any name you want on that contact, correct? So if I got you as your contact, I could put you down as Joe Smith, right?
Are you talking about as a contact in my phone or on Facebook? No.
On your phone. Oh, you're right. On your phone, I can put you down as.
In my phone, yes, as my personal contacts in my phone, yes.
And it's possible to take photos and stuff and make a duplicate Facebook profile of someone, correct?
You can do that, but it would be challenging to do that and then post-date it from 2020.
Would it also be possible if you did a fake profile like that to look at the friends that are on the original person's list and friend those people too?
As long as they accept it, absolutely.
And when you tag someone on Facebook, you type in a name, correct? Am I right?
Yes.
Yeah, I do that bit on Facebook too. And similar names will pop up when you try to tag someone, correct?
Correct.
And when you're doing it quickly, sometimes it's possible to tag the wrong person, correct?
Yeah.
And you didn't see who was actually physically witness Mr. Salunek actually controlling this account or any of these messages, did you?
No.
Nothing further.
May you redirect?
No, Your Honor.
Ms. Kennard, you missed that.
We have no further witnesses, Your Honor.
Defense?
Remember, if you get up on the stand, she can cross-examine. I don't use that temperament. Okay. I mean, I'll be honest. And at this point, I'm doing whatever. Okay. Nothing else, Your Honor.
Mr. Salunek, I don't think there's any question that you have violated this court's order. This is not some manufactured ploy by the alleged victim in the case. I ordered you and I cautioned you about contact. Your bond is revoked. Was that due to your time issues, Ms. Hyatt?
Your Honor, I will
Oh, there's a
calculate
time
that.
waiver filed, never mind.
There was a time waiver filed, Your Honor, that is
All right.
correct, thank you.
That's
Sorry.
it. Thank you.
No.